But with respect to the Less is More Act, I think the very name of the act signifies that both legislators and prosecutors are understanding that lengthy terms of supervision, those above a year or two, are actually more harmful than beneficial. So I believe that this court, when making this assessment and taking into consideration whether Mr. Montalvo should receive a 3-year term, I think it's relevant that now the legislature has spoken and said what the act actually says: less is actually more. Decreased supervision is going to be better not only for the defendant, or the appellant rather, but for society as a whole. And that's why I think that the act actually augurs in favor of the reduction. And in support of that,
I thought the act also does a more holistic approach, in the sense that in the old days, if you sneeze the wrong way, you're going to go back in. Now, if there are certain violations, it's not an automatically in. In other words, I mean, there's more of an understanding of looking at the circumstances that are surrounding the situation as to whether or not there was a violation that warrants to reincarcerate the individual.
That's correct.
So you can't. I mean, there's many versions or iterations of this law.
Well, Your Honor, in response to that, you're right. That is one of the provisions of the law. But what I think that we need to take into consideration as well is that it's not just the technical violations that this act is meant to address, but decreased supervision is also beneficial because supervision in and of itself requires the appellant or the defendant to, do things like meet up with their parole officer, have to do things at certain times, and that over a period of time can actually be more harmful. Keeping those appointments, making sure that you're doing.
Why is that harmful? How's that harmful? Where's the prejudice? How is it harmful?
Well, I mean, I think that one of the things that the reason why people do believe that, and there's been research saying that 1 to 2 years supervision above 1 to 2 years is harmful.
So all that research was done before this enactment of this new law, so that all that research is under the old law, which was very onerous. I'd like to know what the research reveals now under the new law, and how this new approach in terms of how we supervise individuals is impacted by this new law.
Well, Your Honor, one of the things I think is a primary response to that is that although we have this law that's been passed and it's going to be implemented and go into effect in March, we're not yet sure how it's going to be implemented, and the contours of it, right?
That's exactly what I'm saying. All the research that you've been pointing to is under the old law, under the more draconian aspects, of the old law. I don't know how this new law is going to impact this individual, because I think under the new law, there's also a chance if the defendant is on the straight and narrow, it actually automatically reduces his PRS under the new law.
Yeah, and I think it's important though to take into consideration that the law in and of itself signifies a kind of policy shift, that there should be reduced.
But am I correct to say that if he acts in certain ways and he is doing the right thing, that there's in the law itself, there's an automatic reduction of his PRS?
Again, the contours have not all been worked out, but yes, there's supposed to be a 30 for 30.
Okay.
But one of the things I'd also like to note, to Your Honor, is that the Manhattan DA's office itself, under its day one policies and procedures that were recently released, and again, these need to be fleshed out as well, but it appears that a crime such as Mr. Montalvo's would not even be charged as a robbery in the first degree today. It would be charged as a misdemeanor that doesn't accompany with it any sort of PRS term.
Counsel, I think this is Kennedy, and I do have a question concerning your earlier statement about lack of a criminal history. I was under the impression that this was your client's second first-degree robbery conviction, where he also used a used syringe in the prior offense, as well as the fact that he also had 2 petty larceny convictions.
Yes, Your Honor. So I don't want to, I hope I did not misspeak. I said that this was the age of 38 was the first time that he had been in trouble with the law. You are correct that there were a series of offenses during a 4-month period of time in which my client utilized this, quite frankly, terrible tactic. But prior to that discrete 4-month period of time when he was in the midst of a spiraling drug addiction that was born out of underlying trauma, he did not have any interactions with the law. With respect to the Queens offense, that offense occurred 2 days prior to this offense. And I think that that's significant, or that's at least relevant, because this isn't an individual who commits a crime, a year later he goes and he commits another crime and he's just a repeat felony offender. This is someone who is in the midst of an acute crisis, which I submit he's addressed while he's in prison. He's had no disciplinary infractions while he's there. This was an aberration. This is not somebody who had a life of in and out of the system. This was just a crisis. Yeah.
I have another question, follow-up.
Sure.
Now, at the time that the PSR was generated, your client also had 2 open arrest warrants for petty larceny, correct?
That's correct. Yeah, it was during the same time period. That is correct. His actions, in no way in seeking a reduction am I saying that his actions were, we should condone them, we should excuse them. He's still going to be subject to our PRS term. What I'm arguing for is that the factors that this court has often looked at in terms of determining whether there should be a reduction, those factors are present here today. And coupled with the significant policy shift we're seeing with the Less is More Act, as well as the Manhattan DA's own proclamations, I believe that this is a prime case that warrants a 6-month reduction here.
All right, let's hear from your advocate. Go ahead.
I just have a question.
You may ask it.
In the Queens matter, what was the sentence that he received in the Queens matter?
In the Queens matter, he received the 5 years as well as and 2.5 years PRS. So he actually received the 2.5 years there.
And that crime was committed 2 days after he committed the offense here in New York County.
That crime was actually committed 2 days prior. So September 18 is when the offense in Queens occurred. 2 days later, September 20th, the offense in Manhattan occurs.
Okay, and this sentence was to run concurrent with that.
That's correct. And it is my understanding, though I'm not entirely sure. It's my understanding that both courts were aware of that. The Queens court was certainly aware of the Manhattan case.
And you're simply just looking to have, since you're running the 5 years concurrent, also run the PRS concurrent.
That's correct. I'd like a 6-month reduction, given that these 2 offenses occurred close in time. Again, they're not signifying a greater or deeper pattern of criminal behavior on the part of my client.
Thank you. All right, let's hear from the people.
Good afternoon, and may it please the court, Jennifer Westwell for the people. I would just like to start by discussing our office's policies. Yes, it's true that they're continuing to develop and take shape, and these policies are not retroactive. They are a framework for how to approach cases with an emphasis on achieving safety and justice. Just this past week, however, in his February 4th letter, the DA has stated that commercial robberies at knife point or by any other weapon that creates a risk of physical harm will be charged as felonies. So, and additionally, DA Brack has emphasized repeatedly that line ADAs have discretion with regards to sentencing offers and charging decisions. Therefore, there's no reason to speculate that this defendant would have received a more lenient outcome under this current framework. Moving on.
The question that I have is, why the difference in PRS? Why the difference in post-release supervision from the Queens County, where he got 2.5 years? Why give him 3 years in New York County when you're going to be running the sentences concurrent?
So it's clear from the preceding minutes that all the parties were aware that there was a 6-month difference between the Queens and the Manhattan sentences. My argument would be that this was defendant's second violent felony offense, so it's perfectly reasonable to conclude that his repeated violent behavior warranted a longer term of supervision.
That's the reason why? Give him six additional months?
That would be my argument, yes, Your Honor. Is the second one, it's a repeated offense.
Okay.
I don't know if Justice Oing is speaking.
Sorry, can you hear me now?
Yes.
Sorry. So when the New York County judge imposed the 3 years, he already realized or was aware of the 2.5 in Queens County, correct?
Yes. Yes. It was within the first couple of pages of the preceding minutes. Yes. Otherwise, pursuant to a fairly negotiated plea agreement, the term of post-release supervision was just 6 months above the minimum, which, again, with the Less is More Act, can be reduced rather quickly. We believe that this sentence was both fair and appropriate and should not be disturbed on appeal. Unless there are any additional questions, I rely on my brief and respectfully request that you affirm.
Thank you. Any
Thank you.
questions, colleagues? All right, Ms. Chowdhury, we'll hear some rebuttal. You have a minute.
Okay. Well, I would just like to reiterate that obviously this court does not need to defer to the trial court. I believe that the ADA's primary argument ignores the temporal proximity between the Queens and the Manhattan offense. And all that we're asking here today is that Mr. Montalvo receive a 6-month reduction. I believe that the Less is More Act, though a comprehensive holistic framework, actually signifies a policy shift that should be taken into consideration. And I submit that, Mr. Montalvo, as I've noted previously, he's not the type of individual that requires a lengthy term of post-release supervision, given that this is truly an aberration in an otherwise law-abiding life. His prison record bears that out with no disciplinary infractions, and he's been incarcerated since 2018. And for all of those reasons set forth, as well as those in my brief, I respectfully request that this court reduce Mr. Montalvo's PRS term by 6 months.
Thank you. Thank you both. All right, the next case for argument is Aetna Life versus UTA of KJ. You may proceed.
Thank you, Your Honor. Good afternoons. My name is Avram Arvan, and I represent the appellant UTA of KJ Inc. I'd like to focus on two things during the oral argument. Number one is that the default, if it was a default, is clearly excusable. And number two is that Aetna Life never made out a prima facie case for summary judgment. The Aetna's Life motion for summary judgment was returnable during COVID-19. We were not appearing physically in court. It's undisputed that I called the court, spoke with the part clerk, was told that there was no motion on that day. I was looking for an adjournment. That was the first time on. If it was the normal times, and I had appeared physically in court in response to that motion, it pretty much would have been adjourned as it being the first time on.
Mr. Dan, excuse me.
And I have a question. You indicated that you made a call to the part, but didn't the part rules prohibit calls and that request had to be made in writing?
In retrospect, that's probably accurate, and I apologize for that, Your Honors. I did not call the actual court, the chambers. I simply called the part clerk and was told there was no motion on that day. So that and there's no dispute that that happened, that was the information I was given. And it's not unusual during COVID that when motions were made returnable initially, the court would fix alternate days for the actual motion to be heard. So I relied upon that statement. But clearly there was no intent on the part of the school to default on this motion. Now, even if there had been a default, the law is clear, and it's not refuted by Aetna, that they had to make out a prima facie case for summary judgment. And it's equally clear in this case that they failed to do so. Aetna issued a proposal for insurance, which was accepted by the school. Aetna then issued a policy of insurance. The motion made to the court for summary judgment is not based upon the policy. It's based upon a proposal for insurance, which by the express terms of the policy is superseded by the policy. At page 5 of our original brief, I actually cite the portions of the actual policy, the contract between the parties, which states that the policy consisted of the policy, the application, the rates on file, the certificates were attached, and any other riders which were attached. The proposal was not attached to the policy. You have the record on appeal before you. The proposal is not part of the policy. Also, the policy specifically states that all prior agreements were superseded. That includes the proposal. And the probably most incredulous thing is that in Aetna's brief to this court, it states for the first time that when UTA purportedly breached the proposal, that a new proposal was issued by Aetna. So the proposal that they relied upon in the court below was not even the proposal for insurance. Now, Aetna argues to this court.
Counsel, I'd like to go back to, this is Justice Kennedy again, I'd like to go back to the prong of reasonable cause, because isn't it true that there were 2 summary judgment motions and you failed to respond to both of them?
Well, the first one I failed to respond to, and that is correct, but Judge Booth vacated that default for the reason that I established. The second time, again, I don't consider that I defaulted. I made an attempt to get an adjournment of a motion on the first time on, and it typically would have been granted but for COVID-19 and the way things were working.
Well, certainly that was in violation of the part rules, because the part rules did not allow phone calls. The part rules indicated that written requests had to be made. But let's stick with this current motion, because since this was an e-filed case, this was filed on February 3rd. So you had plenty notice of this motion. It was filed February 3rd.
I don't dispute any of those facts. Counsel for Aetna, I approached counsel for Aetna for adjournment. They refused, so I tried to contact the court on the return date. But the second phase of my argument is that even if it is a default, Aetna is not entitled to summary judgment. Aetna has not refuted any of the cases which I have cited, which clearly state that in order to get summary judgment, even if there is a complete default, you have to have made out a prima facie case. Aetna takes the position at page 14 of its brief, and I will read this to you.
No, you don't have to do that, Mr. Van, because your time is up. I'm going to let Aetna speak for itself. So let's hear from them. Go ahead, Aetna.
May it please the court. My name is Yelena Serwin, counsel for respondent plaintiff Aetna. First, I'd like to address some of the arguments made by the appellant. Appellant is claiming that there was no default. Appellant, the trial court clearly articulated its reasonings for finding that the appellant failed the standard to vacate the default. Appellant received proper notice. Appellant did not oppose the motion. Appellant failed to request an adjournment from the court. Appellant defaulted on a prior motion for summary judgment. These facts have been conceded by appellant, and given these facts, there was clearly a default. The alleged improper ex parte phone call to Chambers on the return date of the motion by which counsel intended to request an adjournment, which, as noted, is in violation of part rules, that is not an appearance. The appellant's arguments fails for several reasons. First, secondly, this is not an appeal of the decision granting summary judgment for Aetna. The issue of whether summary judgment was properly granted exceeds the scope of this appeal. The appeal before us is of the order decision.
This is judges. You have to admit they're somewhat interrelated in that that the second prong of excusing a default is whether there's a defense, and if the defense is that you don't have a contract that supports your cause of action, that's a pretty darn good defense, isn't it?
I agree that that would be a good defense if that was the situation here. However, if the appellant wanted to argue that that the respondent failed to make its prima facie case, then at least as part of the record, there should have been included the order actually granting summary judgment. This order is not in the record. There is nothing in the record stating why summary judgment was granted. In fact, if the order was included, it would have stated that the court reviewed all 20 documents submitted, which included affidavits, exhibits, not only the 4 documents that were included in the record. There were other facts to be considered. And given that the whole motion for summary judgment has not been included in the record, it is Aetna's position that there's just not enough documents to permit this court to review the issue of whether summary judgment was properly granted.
Okay. All right. We're going to hear from Mr. Van. You have 2 minutes for rebuttal.
Thank you, Your Honor. First, with respect to the record on appeal, I submitted a proper record on appeal. In fact, there was Aetna argued that I didn't follow the appendix rules, which is completely inapplicable. And if Aetna felt that additional documents were needed for the court's review, they could have contacted me and requested it or sought leave to file a supplemental record. They did not. The most important thing is that Aetna does not deny, and even today does not deny, that their motion for summary judgment was predicated upon the proposal, which was absolutely superseded by Aetna's own contract, and that therefore the motion, there was never a prima facie case made out for summary judgment. To the extent that there might have been a default, I would submit that in the interest of justice and the merits and having a case decided upon merits, the court should vacate the default, as I previously argued, and that Aetna absolutely failed to make out a prima facie case for summary judgment. There's nothing in the record to indicate that they did anything other than move on the proposal. It's not even denied by counsel today. That proposal was entirely superseded by Aetna's own contract documents. This is a
Mr. Van, can you hear me?
Yes, I can.
Stillman. Good afternoon. I have a question. If you believe the proposal was the contract and not the policy, that the ratio of the premium should be based on the 2.67 number rather than the 7+ percentage that Aetna changed, according to you, wrongfully. Did UTA ever pay any premium on this contract?
Oh, absolutely. Premiums were paid for the first 2 months at the rates that were originally invoiced by Aetna. It was when they got a restated invoice which violated the terms of the contract, not the proposal, but the contract, that they separated from Aetna.
So when they said, so in other words, you paid premiums for August, September, October?
For August and September, and for until whenever the termination date took place. Yeah.
The other question I have that I couldn't quite understand is the original proposal has 40 members enrolled in the policy, in the group policy, and apparently it must have increased to cause the ratio to change. And then they paid out almost $250,000 in claim benefits between October and, say, December. How do you explain in the record how in December there were no members enrolled so as to warrant Aetna terminating the policy? How did that happen? I don't understand it.
I cannot explain Aetna's payments because we never had a chance to take any deposition of Aetna, so I never got a chance to depose them on any issues concerning payments made by them or for benefits. It may just be that claims were submitted and then processed later on. That's a very possible reason for it. Certainly no claims were submitted for any benefits after the policy terminated and UTA got a new policy with another insurance company for the benefit of its staff. But the bottom line is that the provision in the proposal with that percentage was never carried into the contract policy, and it's the contract that governs the relationship of the parties.
We understand your argument. Thank you. Thank you both.
Thank you, Your Honors.
Okay, YH Lexus States versus HFZ Capital.
Good afternoon, Your Honors. This is a CPLR 3213 case. That statute provides a fast way for creditors who hold written payment instruments to get to judgment against the debtor very fast and very inexpensively. And my client was unfairly denied the benefit of that speedy path as to the two defendants at issue. The case concerns instruments from July 2020, memorializing an $18 million debt. My client sent multiple default notices starting in early August, within days of the execution, when the first payments were missed. And over the next 3 months, the defendants paid back $2 million and never questioned the validity of the instruments, either the entity's promises or the guarantee. And when the payment stopped, we sued in November 2020. The IAS court's rationale for denying 3213 relief, which is set forth both in the written opinion and in the transcript of the hearing, is directly at odds with this court's 3213 precedents. And I'll note that the court, after multiple rounds of briefing, came up with this particular rationale sua sponte. So we did raise the relevant precedents at oral argument, but it was never briefed. So that explains, I think, what happened here. As an aside, the defendants in their briefs try to tell you that the decision below was based on some other determination, that the instruments here didn't qualify for 3213 relief. That's just revisionist history, Your Honors. The IAS court did grant 3213 relief against one of the three defendants, and in that decision, the court said exactly the opposite of what the defendant's counsel say. So that's just not correct. So here's what the actual decision was based on. The court said, and this is among other places in the transcript at page 66 of the record, that it was declining to consider whether the evidence, the facts raised by the defendants in support of their asserted invalidity defenses suffice to create a triable issue. That's not the law on 3213 motions. The Phillips case cited in our brief provides a very clear statement that merely invoking defenses that are outside the four corners of the instruments does not preclude 3213 consideration. The standard that should have been applied and was not is as follows. Once we, the plaintiffs, came forward with our prima facie case based on the instruments and non-payment, defendants had the burden of introducing not just arguments, but evidence sufficient to create a triable issue of fact with respect to a bona fide defense. And on the record, Your Honor, which the court below didn't reach because of its procedural decision, there was no evidence sufficient to create an issue requiring discovery, let alone a trial. For the entity defendant, HFC, a real estate firm, all you need to know is that entity continued to pay down its debt for 2 more months after the July agreements. There are, in the record, evidence of $2 million of payments. They came in $500,000 and $250,000 increments over 2 months. And those payments came after my client sent multiple people, including the principal of HFC, the individual defendant, Mr. Feldman, default notices, which attached copies of the instruments. And in response, Mr. Feldman, the principal of the company, never questioned the validity of these instruments, and he knew the payments were being made. The ratification by payment evidence should, at the very least, have put the nail in the coffin of the entity HFC's defenses, just as payment evidence did in the Cooper case cited in our briefs, a 3213 case in which the First Department, rejected invalidity defenses based on overwhelming evidence that the agreements were ratified by payment. This is not in our briefs, but just last year, shortly after this motion was decided in June, in Bronson versus Jacobs, which is at 195 83rd 550, this court reached the same conclusion, relying on ratification by payment evidence in granting a 3213 motion over invalidity defenses. And the defendants have never identified any case from the First Department which reached a different conclusion. You don't need to reach this issue, but
right,
the record...
Yeah, okay. I'm going to ask you to save some time for rebuttal. I'm also going to apologize for everybody. My camera is on the blink, but I will assure everybody here that I can see everybody, I can hear everybody, and I'm sure you can hear me as well. So let's hear from your adversary, and then we'll come back to you, Mr. Hatchmiller, for rebuttal.
Thank you, Your Honor.
Thank you.
Thank you, Justice Gish. My name is Christopher Melito from Morris & Cohen. Represent the respondents HFC Capital Group and Zeal Feldman. Your Honors could be forgiven for reading the briefs in this case and thinking that a 3212 motion was being argued. The arguments, the evidence that...
How do you know what we were thinking?
I know.
Don't presume. That's my only point.
I do not.
Okay, go ahead.
Go
ahead with your argument.
Thank you, Your Honor. I do not presume, but for Mr. Hatchmiller to say that...
Judge Owing, why is it then that Mr. Muir, I think the individual that got summary judgment against him on a 3213, why doesn't he have clothed in apparent authority to act in behalf of HFZ?
So first, I note that Mr. Mayer's grant of 3213 against him was under a guarantee, which there was
answer my question. I'm just zeroing on the question. Why isn't he viewed from a third party, viewed from somebody outside, looking at him clothed with apparent authority? What did he do that should have told the other side he doesn't have apparent authority? Because from the record here, he seems to have been doing a lot of stuff that would let anybody doing business with him, oh, this guy's got apparent authority to execute these documents. Particularly when the secretary puts in an affidavit, when we're talking about the handwriting, says that Mr. Mayer had authority to fire her, or at least she thought he could get fired because she took instructions from him in terms of how to do, how to go about doing things in the office.
A few points, Your Honor. The first is that the mere fact that we're wading into the fact issues of ratification, which is a factual intensive.
I'm not talking about ratification. I'm talking about
apparent authority. Even on apparent authority, perhaps even more fact intensive. The fact that we're talking about apparent authority in the context of a 3213 motion is proof positive that this case was inappropriate for resolution on 3213. But even if the court were curious about whether Mr. Meyer had apparent authority, the evidence submitted to the court below, viewed through the lens of the applicable law, which is whether the principal communicated to the counterparty, which is the appellant here, something misleading that led that counterparty to believe that
How about the website? How about HFZ's website, which has him identified as managing principal of HFZ?
The website, interesting point, Your Honor. In the record on the court below.
Yeah, I told you, as Justice Gitt said, we're not confused about 3213 and 3212.
I didn't mean to suggest that anyone was, Your Honor. There's no evidence in the record that anyone from appellant, its manager, its principal, ever reviewed the website or ever reviewed any of the other things they're talking about, which were some 10-year-old litigation.
Well, hang on a second. You're just saying that your website, your client's HFC's website, that identified Mr. Meyer as a managing principal, you're now telling me that there's nobody on your side that actually reviewed what was put on that website, that it was put up there, and that we now disclaim any knowledge of what's in that website.
No, not at all, Your Honor. What I'm suggesting is that Mr. Meyer, the person who acted outside of his scope of authority, was the one who took that title upon himself, and the record below indicates that he gave himself that title. As well, the more important legal question.
So did he create the website? Did Mr. Meyer create the website? Because I saw a lot of people in that website with their titles and their photographs, just like I saw Mr. Meyer there with a title and a photograph. And by the way, there's one of Mr. Meyer next to Mr. Feldman. So how could he have done that and no one picked it up and called maybe him to attention?
Again, Your Honor, the record below is silent on how it came to be, but the website itself cannot create apparent authority. Certainly just giving someone the title that they gave themselves, managing principal is not a specific legal term.
I'm sorry, go ahead.
HFC Capital Group is an LLC. I'm sorry, Justice Goldberg.
I'm sorry, I apologize. Justice Doing, may I ask?
Yeah,
okay. I'm a little confused. On this record, we're talking about negotiations between your client and the appellant, where your client got $20 million through the efforts of Mr. Meyer, whether he's an apparent executive principal, whatever title you want. He was the point person that negotiated on behalf of your client and got $20 million, which directly benefited HFZ and of course, Mr. Feldman. And we're talking about discrete promissory notes that he signed. And the discrete promissory note pursuant to 3213 encompass all the material terms within the four corners of those documents. So there's no real challenge as to the promissory note. What I see here is Mr. Feldman, after benefiting and receiving $20 million for his company and proceeding with his development plans, and obviously being copied all the emails back and forth and getting the notices from Mr. Heyman on behalf of the appellant saying, look, we're defaulted, we're renegotiating a repayment, we're renegotiating at a third time for the third agreement to draw it down from 20 million to 18 million with the whole payout plan, all that stuff. And your client now, after benefiting all that, is saying, oh, wait a minute. I think my signature was forged on the guarantee. Oh, wait a minute. I think it wasn't, it was my secretary who signed my name. It's not the forgery that I argued the first time in terms of conflicting affidavits, which is, a fair, you can raise that as a defense. So what I need to understand, sir, is if the notes are clear on their face for payment of money only, and if there's an issue as to whether Mr. Feldman signed as a guarantee, any of the guarantees, et cetera, to be obligated personally on those notes, does that, as a matter of law, undermine the 3213 component that establishes that the very documents in issue are for payments of money only? Do you understand the question I'm asking? Like, does the defense of forgery in any way, shape, or form, did that really require us looking at an extrinsic document to add clarity to any ambiguity here when there's no ambiguity here?
Well, it certainly requires, and I think I do understand your very good question, Justice Schulman. It certainly requires the court to review extrinsic evidence, which Justice Cohen below mentioned in his decision, that he required extrinsic evidence to decide this case. And to the court below, we cited up and down that defenses of the defense of forgery, the defense of lack of actual authority or apparent authority, those are real defenses to 3213 actions. The document being sued upon has to be a real document. And to be clear, it's not just promissory notes. There are 8 of those, plus the amended promissory note, but there's a whole other set of ancillary agreements, letter agreements. And all of those letter agreements state that these were convertible notes, meaning they were designed to be a front for an investment. And what happened over the course of 2 years is all of these, now at 16 documents from the beginning. Then there's a repayment agreement. The repayment agreement says that it consolidates the notes, but there's no consolidated note. Then there's an amended note, an amended repayment agreement. And I think this is important to note. If you look at the amended repayment agreement and the amended note, there is a disconnect on the increase of interest rates. Well, is it 12%? Is it 15%? So in addition to the apparent authority question, in addition to the forgery question, there's not just one document that's being sued upon here under 3213. It's 19 different documents, which in some parts do conflict with each other. And I would just like to end, Your Honor, I see that my time is coming to a close.
Your time is way over. I let it go over because you were asked questions. So you weren't keeping track of your time. I was. You're about twice as much time.
I appreciate that.
I want you to know I am still here, even if you can't see me. Go ahead.
I appreciate that. The parties in this case, and to the credit of all the attorneys, have done a yeoman's job in taking and completing discovery in this action from the June decision until now. We're done. We're briefing summary judgment.
Okay, good to know. Thank you. Let's hear from your adversary. 2 minutes on rebuttal.
I'll return the great compliment to Mr. Melito. He's been a worthy adversary and a good guy to work with. But
Let me ask you this, Counselor.
yes.
This is Judge Owen. He mentioned 19 documents. My understanding is that all these 19 documents are however umpteen million documents you're dealing with. That doesn't really affect the core of a 3213 motion. I mean, I've seen cases where, you know, the 3213 motion can go forward even when you're dealing with multiple documents, so long as you strip it down and it's a payment for, it's an instrument to pay. It's an instrument for the payment of money. So you could have like a gazillion documents, but if it at the end of the day, all gazillion documents say it's an instrument for the payment of money, that's it.
Absolutely correct.
And the fact that you have to look at extrinsic evidence to demonstrate, to prove your defense, that does not undermine the 3213 aspect of it.
Correct.
It only undermines the 3213 if you have to refer to extrinsic evidence to prove your 3213. That you're entitled to 3213.
Correct. And the question's not whether the defendants come up with an argument, you know, a clever one, a creative one. It's do they put in evidence that raises a tribal issue of fact? And use your common sense here. You know, nobody gets a $20 million debt instrument and lets their company start repaying it and says nothing for 3 months. That just doesn't happen. No jury needs to see this. We shouldn't have to pay for more rounds of summary judgment briefing, wait for more hearings before the trial court. The case should this matter should be resolved now. Thank you, Your Honors.
Thank you. Thank you both. The next case is Finkelstein versus Finkelstein.
Yes, Your Honor. My name is Stuart Blander, and I represent the appellants. The arbitration awards and the judgment confirming the arbitration award should be vacated for a host of reasons. I want to focus on 3 in the time that I have. The probate exception to arbitrability, the fact that the clarified award violates 7509, and the bias, the undisclosed bias of the purported neutral arbitrator, in this case, Rabbi Rosenberg. With respect to the probate exception, everybody agrees, there's no dispute, that an arbitrator does not have authority to address matters relating to decedents matters and to decide which wills are good.
This is Judge Gish. Here's my question, though. The property was held in a trust, though, correct?
That is correct. At the time of death.
And the court has jurisdiction to determine matters related to trusts, doesn't it? That's not a probate.
You mean the arbitrators, Judge, right?
I meant the arbitrators.
Yeah.
I mean the court too, but the arbitrators, yes, thank you.
Yeah, no, I didn't. No, the answer to that question is generally yes, but I think that in this case, if you look at what the arbitrators actually did, and we don't have to guess about that, but you look at the face of the award, and the award is on page 52 of the record, the first award. It specifically says what we are doing is we are deciding that will A, that is proffered by party 1, is good, and will B, that is proffered by party 2, is no good. The parties presented evidence as to testamentary capacity. The parties made arguments as to the intent of the decedent, the father, as to what he wanted to happen with his assets after his death. Functionally, it was everything that a surrogate would do. The only difference is that rather than at the time of death, these assets were titled in a trust rather than titled in the name of the father. But functionally, practically, morally,
this is Judge Gish again. That's a significant difference, though, because the surrogate's court can't change the title like that, and a probate proceeding would only involves a disposition according to the will. But if the property doesn't pass within the will, then that's not a probate. The surrogate's court can't do that. This is so different than a surrogate's court proceeding, at least as I'm seeing it, that I don't really understand this argument entirely.
Well, that the argument is, Judge, that if you look at what the the arbitration panel actually did is they heard testimony as to testamentary capacity. They heard testimony as to undue influence.
I understand that, but at most that's a legal mistake. It doesn't make it a probate.
Well, I don't think it's a mistake because they were very upfront what they were doing. They were deciding which of the.
They could be upfront about making a mistake. When you're mistaken, you're mistaken. In other words, if arbitrators make mistakes of law, so be it. That's not a reason to undo an arbitration award.
Well,
they decided on the wrong ground.
Well,
that's the way it is.
Okay, I wanna focus on my other two arguments, but before I leave it, if you look at 52 of the
Counsel,
52 of the.
Counsel, I'm speaking.
I'm sorry.
No, it's fine. This is Justice Kennedy, and I have a question. You know, how was the award a clarification and not a, I don't see how it was a modification, since the award really didn't grant any relief different from the initial award. I mean, what you have here was the fact that the award specifically identified which entity should hold legal title to assets, and certainly the intent to award the properties to the children pro rata. So how is that a modification when it's still the same relief?
Well, first of all, it's a modification because it was called a modification by the respondents, and it is not the same relief for one very important reason. The foundation of the clarified award, Your Honor, and it's clear on the face of the clarified award, is based on two trust instruments and two trusts. It is undisputed that those trusts were never, ever presented to the panel in any of the prior proceedings, and they were essentially pulled out of the air for purposes of the clarified award. That's point one. Point two is, if you look at the statute, Judge, and I'm sure you have, 7509 says that once an arbitrator has rendered an award, the arbitrator is, I'm going to mispronounce this, you'll forgive me, is functus officio, which means, I think, that the arbitrator goes out of business and has no authority to do anything else except for one thing. Within 20 days, somebody can make an application, and then the arbitrator has authority to modify the award. Now, when I say modify, I mean issue a new award for three reasons. There's an imperfection.
You're way out of your time, so I'm going to ask you to briefly finish up your answer to Justice Kennedy's question, and then you can save your third argument about bias for rebuttal.
Okay, thank you. Under 7511, the only authority as a matter of law of an arbitrator after an award has been rendered is to correct a misidentification of property, that the dispute concerned Blackacre and the award says Whiteacre, or for a miscomputation. 12 months at $1,000 a month, and I'm awarding $15,000 instead of $12,000. That's not what happened here, and there's no suggestion it happened here. So as a matter of law, these arbitrators had no authority 8 months later, not 20 days later, 8 months later.
You understand your argument. Thank you. Let's hear from the other side.
Good afternoon, Your Honors. This is Gregory Cronin of Blank Room. We've made a application for William J. Dorsey of our firm to participate pro hoc vice, which has been granted by the clerk of court, and I just raised that application to Your Honors now.
Are we granted? Thank you. You may proceed.
Thank you, Your Honors. I appreciate it. This is William Dorsey for the respondents in the appeal. One thing I wanted to address right off the bat is that this was a rabbinical court proceeding, which is being treated as an arbitration. And the parties understood that under rabbinical law, which predates the existence of corporate formalities, there was an understanding that the person's intent should be honored. And so even though the parties knew that the funds and the properties were all held in trust, they agreed to honor their father's wishes by looking at not a
I know, but we're not really being called upon to otherwise decide an issue of rabbinical law. this is being looked to as being confirmed as an arbitration. So whether it's correct rabbinical law or incorrect rabbinical law, or it doesn't comport with civil law, I don't really see that that's a particular issue that's actually before us.
I agree, Judge. I just wanted to point out that I don't think that the rabbinical court got it wrong. They were looking to what the parties asked to.
Even if they did, arbitrators get things wrong all the time, and that doesn't mean we're free to set it aside.
That's true. And it also doesn't make it a probate issue when all of the assets were held in a trust. So just because you're looking to the intent of the father in his will, his rabbinical will, it doesn't make it a probate issue if everything is held in a trust and doesn't pass through probate. And that's what the cases that we've cited and Mr. Blander cites. He's expanded it beyond what the law provides.
Mr. Dorsey, this is Justice Shulman. Not necessarily to preempt your adversary, but the issue of bias. Didn't one of the judges, Rabbi Rosenberg, disclose that he had some connection with the 2009 will of the decedent father?
Absolutely. So Rabbi Rosenberg met with all of the family members, including Reuven, who's Mr. Blander's client, met with Jacob Finkelstein, met with them individually, and was involved in the preparation of the New York will, or the 2009 will that you're referring to. Everybody knew it, and in connection with a post-dispute agreement to arbitrate, agreed that he should be one of the 3 arbitrators. And so there's no argument here that everyone knew going in that Rabbi Rosenberg had a significant role in the connection with the preparation of that original document. And that's why the parties wanted them. And we've cited the cases that say you don't have to pick an outsider to the issues to help resolve them. And here it is clear that Reuven knew that Rabbi Rosenberg was involved. And it's, by the way, Mr. Blander's client's burden to show by clear and convincing evidence that there was some sort of a conflict here. In this instance, Rabbi Rosenberg, and we've cited 3 people who were there on the very first day, said, everyone knows that I was involved in the preparation of one of these wills. If you have an issue with it,
isn't there at least an issue of fact about what everyone knew when?
I mean, first of all, I think that Mr. Reuven Finkelstein's own admissions are alone sufficient to find that there was no bias here. But, you know, we have 3 people who were testifying about what happened at that first meeting. I don't believe Reuven has put in a conflicting affidavit saying that that's not what happened. So with that,
would what he knew in terms of the involvement of the rabbi prior to the arbitration, did that trigger any duty of inquiry to see if there was a conflict there?
Yeah, we've cited all the case law that says as long as you're on inquiry notice of a potential conflict, it is upon the party to the arbitration to get to the bottom of it and address it. And Mr. Reuven Finkelstein's own admissions confirm he knew he was involved in the drafting of the will, he'd met with Reuven about the will prior, and he knew all of this before it even commenced. So that would certainly be enough to constitute inquiry notice. And you know, obviously, at least that was never done.
Mr. Dorsey, didn't the petitioner have to get written permission from the arbitrators to go to court to conform an award, or no?
Well, so that provision is clearly intended to affect a party's ability to go get injunctive relief during the pendency of the arbitration. It just says there has to be an authorization from the rabbinical court before you go seek court relief. Here, that authorization is the award itself. There couldn't be a clearer indication of you are now authorized to go implement this award than the final award itself. So the argument, I don't quite understand the argument that they're making on that point. It's clear on the face of the award that it's a final award. It says it's a final award.
All right, let's hear from your adversary, his rebuttal. If you could address the bias issue in particular, please.
I will. There is no doubt that we knew that Rabbi Rosenberg had some involvement with the will and that he knew the parents. There's no doubt about that. But we didn't know the most important fact, which is that he was the author of the plan, of the estate plan that was contained in the will. So we did not know. And as far as inquiry notice is concerned, we did make inquiry. And it is undisputed, and this is on pages 119, 123, 127, and 128 of the record, that when we made inquiry of Rabbi Rosenberg, he said in Yiddish he was a bystander to the will. That is, he was involved, but he wasn't the author of the plan. We also did not know, and this was not disputed at all. What the claim by the respondents was that there was disclosure, but there was no claim that Rabbi Rosenberg did not do this. And in fact, there was no claim that he disclosed these specific matters, including that he had prepared 3 or 4 drafts of the so-called New York will, that he had met with the parents without Ruvain Finkelstein, and he had detailed notes of these conversations. So what it comes down to is, unbeknownst to my client, he is arguing against an instrument that was prepared and that contained an estate plan that was endorsed and recommended by the neutral, the purported neutral in the panel. It's as if a surrogate, prior to becoming the surrogate, has a client, the client prepares a will for that client, and then when she becomes the surrogate.
It's not really, because you can have conflicted arbitrators. That's clear. You're allowed to pick a conflicted arbitrator. That's always been the rule. Yeah,
I agree, but for example, in the J.P. Stevens case, which is sort of the grandfather of all of these cases, the parties are allowed to say, I want somebody who knows the textile business, so I'm going to appoint somebody who knows the textile business and is involved and may know the parties because it's a small world in the textile business. That's fine. But what we didn't know here was the single most important thing, which is that the wills, the issue was will A or will B, and we did not know that Rabbi Rosenberg, the neutral, was the author and the preparer and the advocate and the recommender of will A. And under those circumstances, and particularly because we asked for clarification, and the clarification we got was that I was a bystander to the will, uncontradicted. They put a lot of affidavits in, but they never, ever contradicted that statement. We were in effect arguing against an instrument that the neutral had prepared. And under those circumstances, it's frankly impossible to say that my client got a fair shake, even though he knew in some general sense, which is what Judge Getz hung his hat on, there was some involvement. And for that reason, we think this award cannot stand. Thank you.
thank you. Thank you both.
Thanks.
Okay, the next case is People versus Brandon Broy.
Bryce, Your Honor.
Broy. Thank you. You may proceed.
May it please the court. While there are a good number of mistakes respectfully made by the trial court below, 2 mistakes sum it up. One is a matter of law, one is a matter of fact. With regard to a matter of law, the trial court announced this sweeping new test for effective assistance of counsel, the entirety of a counsel's performance. And that is, if there's a guilty plea and the person gets a sentence below the maximum, here 15 years, 10 years, 5 years, 3 years, 2 years, it is presumptive effective assistance of counsel, notwithstanding any evidence to the contrary, notwithstanding any interest by the court to examine anything else.
What was the evidence, counsel, what was the evidence that the attorneys here were ineffective?
Well, the evidence here is I submitted under pain and penalty of perjury that I had spoken to former counsel and the prosecutor and learned that the DA's office did not convey to counsel that if he proceeded to a suppression hearing and lost.
That was an affidavit, an affirmation?
That was an affirmation by me.
Was that in your legal briefs?
It was in my original motion pursuant to 44010. It was submitted 2 subsequent occasions. It was argued in 4 different places with the very prosecutor who prosecuted the case in the courtroom. Not once did they deny it.
But
not
your
once did they challenge
motion,
it.
your original motion was based on the lack of on the failure to submit
That's
a
correct.
motion to obtain a hearing to suppress the evidence.
That's correct, Judge.
That was your original motion.
I came in at the last minute, and when I discovered what had happened, I moved for a supplemental brief, which incorporated all of my prior affirmations. And on 6 separate occasions, I repeated it in front of the prosecutor who handled the case. I did it twice more on papers. I did it 4 times in front of the court. Not once did the prosecutor say, Cohen, you're wrong. It's a mistake. You're disingenuous. It's not true.
But was it true that no motion was made to obtain a hearing to suppress the evidence?
No, but I supplemented that by a second motion that said it's a difference without a distinction. The motion was made, but then wasn't pursued.
So the ineffectiveness was second counsel's ability to have gone and done the hearing. That was the ineffectiveness.
The ineffectiveness was 2 things. Number 1, it was second counsel's failure to pursue a meritorious claim that on its face the trial prosecutor never denied. Failure number 2 was the court taking, and the people come before this court and they say, notwithstanding the trial counsel, the DA's silence about these repeated allegations which we raised, 1 under affirmation, the people come in and say it's common practice. It's common practice in our office to demand a quid pro quo. I don't know what common practice is. Is that 1 case? Is it 30 cases? Is it 50 cases? The whole purpose of 44010 is this particular case. In this particular case, we had multiple averments that this was a winnable suppression hearing. The officer's testimony in the grand jury made out 4 corners of a suppression issue. The people did not say there was a quid pro quo. The defense attorney told the defense.
How did they arrive at that plea offer? How did that come about?
There were several meetings, there were several discussions, and then a plea offer
between the prosecutor and the defense counsel?
That's correct.
And was the defendant involved in these discussions?
The defendant was not involved. The first time the defendant was told, as in his affirmation, that here's the plea offer, you got to take it. I don't believe you. You can't win this. Was standing outside the courtroom that final day where a young man, a 21-year-old with a certified history of mental health issues, cognitive deficit disorder, ADD, post-traumatic stress disorder.
Did the defendant appear at any proffer sessions with the prosecutor before he was offered the plea to 2 years?
He did. He appeared at 2 sessions.
How many proffer offers did he appear?
2 sessions where the prosecutor spoke to him about other matters, about other situations upon information and belief. And at the result, at the end of the second session, they said, fine, to the defense attorney, we're going to give you an offer of 2 years. That was not conveyed to the defendant. And the whole purpose of the 440 is we have the people's failure to respond to any of the assertions. We have an affirmation from the defendant. We have affirmations from his parents. We have the people simply saying it's common practice. We have a report from Dr. Draub. We have more than enough that the board
that they will make an offer, to a defendant so as to not have to go through a hearing and a trial.
Yes, but it's not common practice to say if you refuse this offer, he's asking you to accept, almost as the court can take judicial notice, that if you refuse this offer, we're not going to keep it open for you. And in this particular case, the people never said that on the record. They never
have to say it on the record. You're saying that if the people don't say that on the record and the defense attorney goes ahead and takes a plea, then that's an effective assistance of counsel?
On a case where there's more than a debar number 2, it is. It is. And in a case where defense counsel did not meet with the defendant prior to the plea, where they did not share discovery, where you had a police officer.
Was there a third proffer session? Was there a third proffer session?
Not that I'm aware of.
Well, I think that the record reflects that there was a third proffer session with the second attorney.
Not that I'm aware of. What I am aware of is that the second trial attorney went to the defendant 5 minutes before he pleaded guilty and said, I don't believe you. You can't beat this. Take this plea. Whatever the judge says, say yes.
And by the way, this is the same defendant that also told you that the first attorney said that he was not going to make a motion to suppress any evidence, and who also told you that the second attorney said, I'm not going to make a motion now because it's too late. Yet a motion had already been made and a hearing had been granted.
Yes, this is the same young man who was diagnosed with having post-traumatic stress, who was diagnosed with having brain injury, and this is why it dehors the record, and this is why there should be a hearing with 3 lawyers, including the prosecutor, with Dr. Draub, with the defendant and his mother and father, so that the court can have before it not common practice, not generic, this is the thing that sort of happens, but facts. Findings of fact, conclusions to support conclusions of law, something that didn't happen here. This is all magical. There was no quid pro quo.
Did Dr. Draub find that the defendant was not competent?
No.
That he did not understand the plea that he was taking, that he did not understand the waiver of appeal?
What he said was, while he was competent, there were significant cognitive deficit disorders which went to the voluntariness. He should have been prepared before the argument. He should have gone over the questions. He should have gone through a dry run. And at that point, and we're not talking about smoke and mirrors here. We're talking about 800 to 900 pages of psychiatric records, which Dr. Draub reviewed from the time this was a young man. One
final question.
Sure.
One final question. Your client pled guilty and was sentenced and was allowed to remain at liberty pending sentencing.
That's true.
And yet, while at liberty pending sentence, he committed another crime.
He was
very similar to the one.
No, it wasn't. He was convicted of possession of a knife and possession of a THC capsule, and he got a conditional discharge on it.
Okay, but that was a felony also, and that was pending.
No, that was a misdemeanor. I don't know what that has to do with whether or not counsel was effective in the first instance, respectfully judged. The bottom line here is the people keep saying quid pro quo with nothing to support that.
Well, let's hear what the people have to say. Thank you, Mr. Cohn. All right, let's hear from the people.
Yes, Your Honors. Good afternoon. Michael Tarbutton for the people. Your Honors, the defendant just wasn't entitled to a hearing on either of his post-judgment motions because the factual allegations that made in support of those motions were perjured. As to the guilty plea,
he wasn't denied the hearing by the court, was he?
On not the suppression motion, Your Honor, the post-judgment motions where he claims an effective.
Oh, you mean on the? Oh, I'm sorry, I misunderstood. Right. Sure. He was granted the right to a hearing on the suppression issue, correct?
Right.
And he entered a plea before that, correct?
Yes, Your Honor. So, and the problem with his post-judgment motions when he's claiming effective assistance of counsel is he claims, as counsel just said now in his motion to renew and re-argue the first time he claimed it, he claimed that his attorney sandbagged him with the guilty plea, that he had never, that he told him that immediately before the proceeding, you got to plead guilty, you're going to go to jail for a longer period of time. He said his attorney had never talked this way before. He never talked about a plea before. But of course, that's in the motion to renew and re-argue. In the initial 440 motion, he talked about how he kept on raising the suppression issue, and the counsel only wanted to talk about a plea. His parents gave in these affidavits too, where they talked about the first and the second attorney were just pushing a plea the whole time. They wouldn't consider a suppression motion. And in fact, his mother, it gives this affidavit in her affidavit that he submitted. Gives this poignant statement about how after 14 months of no changes in the case, after hearing that this was the best deal we're going to get, we were resigned to our son having to plead guilty and go to prison. That's not being sandbagged with a plea deal as he walks into court. He contradicted himself, and this was the evidentiary basis he made for his motions. The first ineffective assistance claim, the first motion, he gives all these details which we know are false about how no other attorney filed a suppression motion. The first attorney laughed at him when he talked about suppression hearing. He said suppression hearings, that's only TV. The second attorney said, well, you can't file a motion now because the first attorney didn't. It's too late. But of course, none of that's true. The defendant's attorney did file a suppression motion. The defendant knew that because he filed an affidavit in support of it. So this was all lies. His evidentiary basis for both motions for ineffectiveness were perjured, and that was obvious to the court at the time. So none of this would get him a hearing. As for the people conceding the fact that there was something wrong with the stop, we never did that. As to the notion that that the prosecutor had told the defendants that there's no risk about going forward with the hearing. According to the papers here, according to motion counsel's statements, and if I don't believe I got this wrong because I checked, but you can certainly look at the papers. Counsel says in 2 places in the papers that the prosecutor talked about whether the deal would be still on the table when forward to the hearing. One of those is a footnote to the memorandum of law, not to an affirmation. The other is to the supplemental letter, again, not an affirmation. And in both of those, It's in the letter, it's unattributed. In the memo of law, it's attributed to conversations with the people and former counsel, not to any particular individual. So this doesn't meet the evidentiary allegations of a Rule 40. Further, the statement that the motion counsel gave was the prosecutor, according to someone, never told a defense counsel that the motion would be offer would be withdrawn if they went forward with a hearing. Never even an ultimatum. That's not the same as saying, contrary to our typical practice, you can go through with a hearing. We're going to keep the motion open, keep the offer open. So this is very carefully. We will never told them that they wouldn't withdraw it. Actually doesn't.
What's normally the policy in your office?
Typically, Your Honors, if you go forward with a suppression hearing, the offer is off the table. Okay. What the only thing the prosecutor said in this case in the motion litigation was that after the third proffer, and there was a third proffer, the second attorney had come in and tried to get a better deal again and brought the defendant in for a third proffer. The prosecutor assured them, well, we're not going to give you a better deal, but we'll still let you plead guilty on that to this. That offer's still on the table. That was before they declared ready and before anyone talked about hearings. So this is before that date. So that's not at all the same thing as saying, oh, you can go forward with a hearing. And also, Your Honors, it's important to keep in mind that 3 proffer sessions, or even 2 that counsel acknowledges now, what are proffer sessions for except to obtain a lenient guilty plea? The notion the defendant was sandbagged as he walked into court is not plausible, in addition to being contradicted by the defendant's own affidavit. Further, Your Honors, the entire motion to renew and re-argue isn't even properly before the court because there's no statutory authorization for appealing that order. It's a non-appealable order. And this isn't just an issue of changing the name on the motion papers. This was a motion to renew and re-argue. The motion counsel captioned that. He argued that through the motion papers. The court denied it on that grounds, quoting the statutory standard under the CPLR for motion to renew and re-argue. That's what this is. It's a different thing than a successive 440-10 motion.
All right, I'm going to ask you to wrap up your argument, Mr. Tarbenton.
Sure, Your Honor. So that's the basis of it, is that the defendant, one final point, if this court were to give the defendant a hearing on effective assistance of counsel, what could he possibly say after having perjured all the fundamental elements of ineffective assistance, given multiple different versions of what happened? What could he say on the stand that any court could accept? He's painting himself to a corner with perjury. And that's why.
All right, we understand your position. Okay, because you're way over your time. Mr. Cohn, stay within 2 minutes, please.
Sure. What I find so interesting here is 2 points. Number one is the common practice argument. Number two, trying to parse.
Well, let's leave the common practice argument aside, because you know what? Even under your scenario, there was no affirmative representation that the offer would be left open, meaning that the risk of it being withdrawn, even under your best case scenario, was a real risk and possibility had he not accepted the plea. That's not an unreasonable evaluation of the case at that period of time and the efficacy of a plea.
Well, what's interesting, Judge, is you raised the argument that the prosecutor himself did not raise in front of the trial court. The prosecutor stood there next to me when I repeated this on 4 occasions and did not say, we didn't commit anything. He took a risk, especially in a case where if you take a look at the facts laid out in the grand jury, this was a winning suppression motion. Lastly, Judge, I just want to respond.
You never know if you're going to win a motion or anything after a hearing. You never know whether you're going to win or lose an appeal, right?
That's true. That's correct. Judge. May I make one last point, because my adversary keeps talking about perjury, a knowing misrepresentation of a material fact. We're talking about a 20-year-old that, no matter what you believe, was documented.
I'm going to stop you there, because you know what? 20-year-olds doesn't mean that you have the right to lie. Having a cognitive deficit doesn't mean that you have the right to perjury. So I think we can end that there. Really, Mr. Cohn, really.
But Judge, I'm not conceding there was perjury. The fact that there may have been.
That's a different issue. That's different, and you don't have to yell.
I'm sorry,
That's
Judge,
different.
My microphone is back.
But don't excuse perjury by his age and cognitive deficits.
Judge, I'm not conceding perjury. The point.
Fine. Understood.
Okay. The bottom line here is, Judge, there are lots of allegations that the people didn't respond to. There are affidavits from his mother. There are affidavits from his father. There's an affidavit from him. There is an affidavit from Dr. Draub, sufficient enough to meet the burden of a hearing. I would respectfully suggest that given the testimony by the police officer in the grand jury, which established more than a culpable claim of a violation of DeBoer, the second standard, that the case should be remanded for a fleshed out hearing for the court to take a look at witnesses, to listen to what they have to say, listen to the prosecutor, listen to the attorneys, and then it won't be tea leaves. It'll be findings of fact based upon findings of law and conclusions.
Thank you. Thank you both.
Thank you, Judge.
All right, Lopez versus City of New York.
Good afternoon, Your Honors. May it please the court. Brendan Fitzpatrick, counsel for the appellants, Lebanon and Mega. Your Honors, I'd ask this court to reverse the Supreme Court's decision based upon the record before this court that shows that there's no evidence of anything wrong with the whip checks that plaintiff used on the morning of the incident. Therefore, without any evidence of anything wrong with the whip checks, plaintiff cannot sustain a claim based upon Industrial Code Section 23-1.5 C3.
Did you provide that information to the court below, that there was no evidence of anything wrong with the whip check?
We relied upon plaintiff's testimony as well as an expert who looked at all the evidence that had been had basically been taken up throughout this entire case. And
so how do you explain the hose whipping and striking the plaintiff?
According to our,
nothing wrong with the whip check.
According to our expert, it was the manner in which the workers made the connections.
But isn't the whip check supposed to prevent that from happening?
Yes, it's supposed to.
But it didn't. And if it didn't, then how did it malfunction? What happened?
The mere fact that an accident happened, Your Honor, doesn't mean that there is a violation. There has to be proof. And we have plaintiff who controlled virtually every aspect of that work this morning. Plaintiff handled the whip checks. He saw Mr. Perez place the whip checks. He saw them place the whip checks into the hoses and into the air compressor, into the drill rig. At no point did plaintiff, who was very experienced and who was the foreman on the job, say that this whip check, you know what, it's bent, it's damaged.
Can I stop you for a moment, though? Yes, yeah, isn't it sort of a fundamental principle of summary judgment that you have the burden of proof and you can't point to deficits in the plaintiff's proof as the reason for you to get summary judgment? That's a fundamental principle, yes. Right?
Yes.
Okay. So other than saying plaintiff can't prove that there was something wrong with the whip checks, where is your proof that the whip checks were just A-okay?
Your Honor, it's honestly, it's based upon plaintiff's testimony as his control over every single aspect of the work that morning.
Did he say that they were A-okay?
He didn't.
Or in substance, not obviously my words.
In substance, he said these were standard whip checks. He never said that there was anything wrong with them. And Your Honor, just like a plaintiff who slips and falls and can't identify what caused them to fall, what we're left with here is an accident where plaintiff never identifies anything wrong that would qualify 23-1.5 C3 as applied.
But even how you're phrasing it, I mean, that just honestly leads me to my original question, is that maybe you'll prevail at trial on this, but you have the burden on summary judgment, and I'm just not sure how you satisfy it because the plaintiff didn't establish that it was defective. On a summary judgment, maybe at trial it's different. The burden changes.
I don't disagree, Your Honor, but when you have a plaintiff who's controlling the work, who testifies as to what was done, and then an expert says that there's no evidence from plaintiff that there was anything wrong. This wasn't that he alleged something in his complaint or he alleged that there was something wrong with the whip checks in the BP. What we're left is plaintiff.
They did malfunction, though.
But Your Honor, there has to be a basis of a malfunction based upon something wrong with the whip check. Simply saying that they malfunctioned because it didn't hold that day, we have an expert saying that it was based upon how they did their work. not with respect to anything wrong with the whip check or with the hose or with any of the equipment. Plaintiffs testified repeatedly this was standard equipment. He had used this similar type of equipment for the last 15 years that he was doing this, where he was a foreman.
And question, Justice Kennedy. I mean, how do we know that? Because you didn't present any evidence that you conducted any inspections. So how do we know that? You conducted no inspections.
Your Honor, I don't know why there was no inspection afterwards, but we do have plaintiff's testimony as to what was done before this incident happened. The clearest testimony that there can be is what plaintiff testified to up to the time of the accident. And that identifies absolutely nothing wrong with it. Because at that point, then you have to come to the notice requirement, which is also identified in this provision, which we made that argument. It really wasn't addressed by plaintiff. That's the Perez case. I don't believe it's specifically been addressed by this court, but the Perez case that we cited to from the Second Department did address it, as well as the Harris against NYU Langone case from the Supreme Court of New York. There is an immediacy requirement. So
was that raised in the court below?
Your Honor, I believe it was. But if it was not, that's something based upon the facts of this case. It can't be avoided. It's the actual it's the straightforward reading of the industrial code provision, which says.
But if you didn't raise it below, how do we have a factually developed record
Your Honor,
to make the decision? It's not just an issue of law, the
Your
issue of notice. That's a statement. It's not a question. Because honestly, you're out of time. So let's hear from your adversary.
Okay, thanks.
Good afternoon, Your Honor. May it please the court, Lisa Como for the plaintiff respondent. A number of things here. First, I'd just like to remind the court that even though the plaintiff was the foreman, this was his first day on the job. He had never worked with this equipment before. I don't think he'd ever even worked with these coworkers before. There's nothing in his testimony to indicate that he either did or was required to perform any inspections of equipment such as whip checks. I certainly think a worker such as himself would be entitled to come to the job site and expect that that had already been done by whoever at the company is in charge of such things. The type of evidence that I would expect to see from the defendant on a motion for summary judgment in order to meet a burden in a case like this would be proof of when the last inspection was. Was there an inspection log? Was this equipment inspected and noted to be in good condition? Did anybody look at it closely and say there was no corrosion on it, that it wasn't crimped or bent? The fact that the plaintiff, in the middle of attempting on a freezing cold winter morning, trying to get hoses to work from a drill rig to a compressor and attempting to troubleshoot that and to get everything up and running, the fact that he may not have stopped and closely inspected, tested, or done whatever it is to look at a whip check, it probably wasn't the first thing on his mind, and that's certainly not unreasonable. It was up to the defendant to carry their burden on a motion like this to show not only that the whip check and the equipment was in fact affirmatively in good working order, had no visible problems or anything that would lead you to believe upon an appropriate inspection that there was something wrong with it, and also that nobody knew about it. They did not raise the notice issue below. In preparing my respondent's brief, I did not specifically address that because it was never raised, but it's exactly the same rationale. If it's up to the defendants as the proponents of the summary judgment motion to prove the absence of a defect in the equipment, they also have to prove the absence of notice. Now that would come from the employer, and interestingly, the employer was their contractor, so they have in the record an affidavit from Mike, who was the drill, they call him Mike, I think it's Majewski, was the drill rig operator, but he doesn't address that issue either. So they had access to the employer who is in charge of the equipment. The plaintiff is not in charge of this equipment. As I said before, he comes to use it. He has a right to expect that it's in good condition. So I think that basically all I really have to say is exactly what the Supreme Court said, which is that the defendant failed to proffer sworn testimony or affidavits made by persons having knowledge of the relevant facts and or documentation addressing the issue at hand which is whether the subject whip check was sound and operable and or was damaged or known to be damaged within the meaning of the regulation. I think that's the heart of the matter and that the Supreme Court got it exactly right. So we would respectfully ask the court to affirm the order appealed from. Thank you.
Thank you. All right, rebuttal?
Your Honor, page 196 and page 196, plaintiff testified quite clearly he does everything to make sure that the work was done safely. He did everything that morning, watched Mr. Perez to make sure everything was done safely. This isn't something where he just goes into a job site completely blind and just accepts everyone else's word for it. He never did that. He testified when he's the foreman, he's the boss. He controls it. He went over every single thing Mr. Perez did that morning, from watching him attach every hose to every whip check and watching the whip checks and then the hoses being attached to the air compressor and the drill rig. At no time did he say anything was wrong with it. And he's the one who, according to his own words, is responsible for safety, the safety of himself, as well as safety for Mr. Perez. So what we're left with is plaintiff saying, if, as counsel pointed out, if there was something, yes, Judge Owen.
This is Judge Owen. You may be correct, and I'll give you that the plaintiff looked at everything, everything was correct, everything was installed right. But that doesn't, to me, if there's something wrong with the whip check or there's something wrong there, and he just didn't, look, do we know if he's an expert on whip checks? Something happened for this whip check to not do what it was supposed to do, right? That's the thing. It did not do what it was supposed to do.
And according to Mr. Cronin, it was how they did their work. Plaintiff may not like it, and their expert may disagree, but when we have an expert saying,
why couldn't your expert say there was nothing wrong with the whip check?
He said there was nothing wrong with any of the equipment.
No, I want to say, why did he specifically say there was nothing wrong with the whip check, that it was operating perfectly? There was nothing wrong with it. There was nothing defective about the whip check.
At page 837, he attested that the whip checks, hoses, compressor, drill rig violated no safety regulations.
It's not, okay, I got it.
Your Honor, again, he's saying that there was no violation of 23-1.5C3. Your Honor, I think.
Got it.
All right. In conclusion, Your Honor, I'd ask the court to reverse and dismiss this complaint. Thank you, Your Honor.
Okay, thank you. Thank you both. Right, the next case is Prada versus 724 Fifth Fee owner.
Good afternoon, Your Honor. Mark DeLue from Sullivan and Cromwell on behalf of Appellant Prada USA. May it please the court. This should be a simple appeal involving application of the plain language of the contract at issue, the Fourth Amendment to the lease. That amendment provides the owner with
I'm going to disagree with you up front. I don't think that this is a simple appeal. And this is a very, very unusual contract revision. But go ahead.
Your Honor, I don't disagree with you that it's a somewhat unique contract provision.
Yeah, I've seen a few contract provisions and it's pretty unique. Yeah, go ahead.
The contract provision is not unclear. The contract provision at issue here, paragraph 5A of the Fourth Amendment says, if owner shall exercise the suspension option, owner shall deliver to Prada possession of the renovated demised premises on the anticipated reinstatement date. Now, it gives the owner a right to extend that date by a year and a half. And then after that, Prada is entitled to rent credits and then ultimately the right to terminate if it still doesn't get the premises. That's a long way off. But that's the binding obligation in the contract. There's no dispute here that owner exercised the suspension option and set the anticipated reinstatement date in March of 2023. And so the contract requires that the owner deliver the renovated premises by March of 2023 or the extended date. And if he doesn't do so, there are contractual remedies that Prada has. After the extension, it's entitled to rent credits and then ultimately the right to terminate. Without any analysis, the court just read these provisions out of the contract entirely. It just said the owner is not required under the lease to redevelop the building, even though all agreed that these were an enforceable set of obligations. The only reason that the trial court gave for reading these provisions out was that the owner decided it no longer wanted to redevelop. but that's not a reason to ignore contractual rights and remedies. On appeal, the owner doesn't defend any portion of the trial court's decision to ignore these rights. In fact, it never mentions paragraph 5A, even though that was prominent in our brief. It barely even mentions any of the contracts.
Can I stop you for a minute? Does the Fourth Amendment, does the operable provision require that your client vacate the premises in order to receive the $5 million?
Yes, Your Honor. What the
and that didn't happen, right?
Well,
that didn't happen.
That didn't happen. And what we asked the trial court to do, we asked for a declaratory judgment and a motion to enforce, was that Prada would like to leave the premises, as we believe, as paragraph 4B of the Fourth Amendment provides. And then at that point, we'll get the $5 million. There'll be an issue. There'll be a letter of credit. But most importantly, the most fundamental issue here is that paragraph 5A provides that the owner is obligated to provide a renovated premises. The date is March 2023. That date can be extended. And under the trial court's ruling, that can all just be ignored. And most importantly, all the contractual remedies for that obligation can be ignored. So that Prada isn't entitled to rent credits, Prada isn't entitled to terminate the provision, as the explicit terms of the Fourth Amendment provide. So for that reason alone, the trial court should be reversed.
The trial court kind of looked at it differently. It was interesting. What the trial court said is you're entitled to more damages. I can't believe I'm having this reverberation. I only have my computer open. And tech told me they can't help me right now.
We're all dealing with this.
God help me. All right. So my question to you is, you are going to get damages here that are the natural and appropriate damages as a result of the owner having breached the agreement and not renovated the premises. The reasoning of the lower court, as I understand it, is that he read the $5 million as a liquidated damages provision and did the analysis under that. What's wrong with that?
Well, Your Honor, I'll respond to the 5 million liquidated damages in a second, but I think the fundamental problem underlying your question about the trial court reading it differently about damages is he read out all of the provisions of the Fourth Amendment that provide explicitly for contractual remedies if there is a delay or a failure to provide the renovated premises. Paragraph 5G provides explicitly that if the owner does not provide the renovated premises by March of 2023 or the extended date, Prada is entitled to rent credits up to $50 million. This is a 22 million per month lease. This is a significant amount of money, and they're entitled to rent credits up to $50 million for a year. And then if they still don't deliver the premises for another year, Prada is entitled to terminate. That's the deal the parties struck when they entered into this contract. And under well-settled New York law, the court is supposed to enforce the plain language of the contract. Now, to your question, Your Honor, about, well, what about the suspension payment? As I said, that's not really the fundamental question, though ultimately that's another part of Prada's damages. Prada is entitled, under paragraph 4B of the Fourth Amendment, to leave the premises once a suspension option has been exercised. Again, there's no dispute, it has been exercised. Once it leaves, it should be entitled actually to the $5 million even before it leaves. That's explicit in paragraph 4B of the Fourth Amendment. Again, it's not up to the trial court to decide, well, I like a deal better if they don't do it, well, we'll just give Prada some amount of damages, I decide.
Counsel,
the contract provides exactly.
Counsel, this is Judge Owen. I have a question. This is Judge Owen. I have a question. Did your client ever vacate the demise premises?
No, that's the basis of the motion under review. We wanted to.
All right. So was there ever an injunction from you enjoining you from vacating the premises?
No, Your Honor. So the history is a little complicated. So originally, the first motion that was. So let me
ask you this question. Hold on. There's a method to my madness. So you didn't vacate the premises. There was no injunction preventing you from vacating the premises. All these dollar figures and all these liquidated damages The way I understand them are all triggered when you leave and vacate the premises. But you never did, so that you were still conducting your business, correct? Or were you not conducting business?
Well, two points, Your Honor. Respectfully, that's not correct with respect to the provisions of being able to get rent credits if you don't get the renovated premises within the reinstatement date. The contract provides that. And then secondly, to be able to terminate. But directly to your question, Prada wanted to leave the premises, and that's why it filed the motion that is the subject of this appeal.
Let me ask you this question. No, you wanted to leave the premises. Everything under this contract that I read gave you that absolute right to vacate the premises. So what is it that you wanted to leave? You could just say goodbye.
What we asked, that's what we want. What we wanted to do is, what we did ask is the trial court to affirm that we had that right. Because here's the problem.
That's where you and I disagree.
But Your Honor,
that's where you and I have a different reading of this contract. Why do you need to ask the trial court to declare that you had the right to vacate the premises? I'm talking about vacating the premises. I'm not talking about terminating.
I have an answer.
When the contract plainly said you can leave.
Well, two things, Your Honor. One, you're disagreeing with the trial court. The trial court said we can't vacate the premises. But the answer to your question, Your Honor, directly is the reason we asked the trial court to adjudicate this dispute was that in the absence of a judicial disposition here, if Prada left, we believe you are correct, Your Honor, that we had the contractual right to leave. But the owner disagreed. It said in writing, we disagree with that. And if we had left, the owner would have attempted to terminate the contract and claimed hundreds of millions of dollars in damages because Prada has now vacated. It is entitled to the rent for the remaining 4 years of, the remaining 8 years of the contract. That would have been hundreds of millions of dollars. That's why we went to the trial court and said, we believe Prada has the right to leave the premises.
But
the owner disagreed.
This is Judge Gish. You don't get a declaration of rights before you take action so that you can do it without any consequences. That's a business decision that Prada has to make at the time and say, well, I can vacate. These are the consequences. And you'd be in court fighting anyway, quite frankly. But I really don't understand the idea that, oh, we thought we could leave, so we asked the court for permission. It just doesn't work that way. I don't see it.
Slightly different, Your Honor. What actually we did under the order at play, we sent the owner a notice in November, and we said, we are planning to vacate the premises at the time that they said they were ultimately planning to do the redevelopment, Q1 of 2021. And so we sent them a notice in November of 2020 saying, we intend to vacate. And we believe that's what the trial court and the contract provide. If you disagree, let us know, and then we can all go to the court and get an adjudication. And that's exactly what happened.
But I understand. But again, you're missing Judge Wang's point and my point, and I think some of my other colleagues, I see that they're listening and scratching their heads. You know, you don't get to do that. You don't get to come down to the court because you have a dispute unless the dispute is what we call ripe. Right.
Look,
let's hear from your adversary. That was a statement, not a response.
Okay, I'll deal with it.
So I want to hear from your adversary.
Good afternoon, Your Honor. I hope you can see me and hear me.
Better than you can see me, yes.
Okay, thank you very much. A core problem with what you just heard from Prada is that it leaves out the fundamental facts that relate so much to what you, Your Honor, Justice Gish and Justice Coyne were asking. Because in this case, when this case was commenced in December of 2019, Prada brought a claim for damages, claiming that it wanted to stay in the premises and wanted to prevent the owner from ever being able to develop the property. It elected to pursue a claim for damages, and it told the court that it would be improper for the owner, which had withdrawn the suspension option, to even try to do it again, that it was an anticipatory breach of the contract. They said that owner had unequivocally said that it wasn't going to develop the building, and that was the basis for bringing a damages claim. Then in April of 2020, after the court's decision, owner made clear again that it was not developing the property, and Prada never said that it wanted to do anything other than to continue to pursue its damages.
So this is Judge Owings. So this is an interesting predicament for the owner. You got a tenant now that got you now that's basically saying, I'm going to stay in this the demise premises to do my business. And on top of that, based on this contract, you owe me $5 million plus all the other monies you owe me. That's basically what's happening here, right?
Well, to the extent that
essentially.
Well, yes, except as the court ruled, Prada didn't get to have it both ways, which is.
I know, that's what I'm saying. I'm saying it's trying to have it both ways,
right.
You know?
Exactly, Justice Owing. And in fact, as the trial court found, Prada made a clear choice to pursue damages. The court correctly ruled that the damages it's entitled to pursue are the damages that accrued at the time it brought its damages claim in December of 2019. And it was only a year later, after repeatedly indicating that it wanted to stay in the premises, that Prada got new counsel. Mr. DeLue was not the original counsel in this case. Prada got new counsel in the fall of 2020 and suddenly decided to file a new complaint that totally abandoned its original election of remedies. Now, this court, in the EZ Eating 41 Corp case at 171 AD 3rd 415 in 2019, in a unanimous decision that Justice Gish participated in, looked at a situation exactly like this. There was a tenant and an owner. And in that case, the tenant made the opposite choice that Prada made here. It chose to vacate, but then it wanted to change its mind and come back and make a damages claim. And the court said, no, you cannot do that. The court said, quote, having elected that remedy, rather than remaining in the premises and paying rent and instead choosing to vacate, they are not entitled to damages. The court expressly said that that election of remedies in this very context could not be reversed. And for the reason you just said, Joyce, Justice Owing, it would be so completely unfair. Now, I must point out, in addition to Prada today having totally omitted the whole history of this case and creating a sort of twilight zone on this appeal, there are two things that Prada did that are particularly egregious in terms of misrepresenting what happened in the court below. First, in its reply brief, Prada asserts at page 13 that it always intended to leave. It was just waiting to see what the owner would do. The record clearly contradicts that. And in fact, Justice Barak said, quote, at R18 in the transcript, in the opinion, in the record, in the opinion below, quote, Prada did not vacate the demise premises and instead continued to occupy the demise premises and pay rent. They were not waiting around. They told nobody that they wanted to have a claim that would allow them to vacate until they got new counsel and suddenly tried to change the case. Second, and this is very, very important, with all of this evidence apparently trying to create some counterweight, they say in their papers at page 10 in their reply brief, remarkably, they say that in January 2021, owner submitted an affidavit in the case saying that he intended to develop the building. That would have been after they submitted their amended claims. That is a gross misrepresentation. That the affirmation that they cite is from January 2020. It was an affidavit that was put in the context of addressing the original damages claims and talking about a situation where the owner sought preliminary injunctive relief because it looked like Prada was, as you said, Justice Owing, trying to have it both ways to prevent owner from being able to ever develop the building and also claim damages. And Justice Barak, when he made his ruling in March 2020, which is not on appeal now, he said that that relief was not necessary because his order addressed the issues in a way that made it unnecessary. And so that quote by the owner from January 2020 to say that it was said in January 2021 is completely misleading. Prada consistently for a year said it elected to stay in the premises.
Okay, Mr. Newith, your time is way over, so I'm going to ask you to wrap up your argument. I will assure both of you, this is a complex contract action, and we have your briefs, and we understand your arguments.
Thank you, Your Honor. I would just wrap up by saying that the court, I think, below very clearly issued an opinion that was meant to be consistent with the election of remedies doctrine, and we believe that it would be consistent with this court's long-standing holdings of the election of remedies as well as the Court of Appeals to affirm Justice Barak.
Thank you.
Before
you begin, Mr. DeLoe, I'm going to ask if there is anybody who was on the Teams meeting who has their phone open, or they're otherwise not muted, and they should be, to please just check and mute yourself because we're getting an echo. Okay.
Thank you, Your Honor. I'm going to address the question you and Justice Oing were asking before I stopped. The reason why this issue was ripe and we didn't just move out without asking the court was it was ripe. We were before the court at this point. We had been before the court. The court had already issued some rulings on declaratory relief, and the parties disagreed about the implications of that ruling. We thought we could move out without terminating the contract, and the owner said in a written response to us, we don't agree. So we went to the court. Now, the fundamental question is, can we move out? If the trial court believes we can't, and so therefore we'd be risking termination. If this court says we can move out, we will do so. And we're not trying to have it both ways. We want to move out, and we want to enforce the obligations of the contract. And most importantly, the problem is that
Counsel, this is Judge Owen. Let me stop you right there. Sure. This goes back to what Justice Gish is alluded to earlier. We're not in the business of telling you what you can and cannot do under a contract. You do what you have to do under the contract, and then you will deal with whatever benefits or consequences that arise from your decision. Because if we were to do that, we should be putting our meters out instead and start charging your client for advice.
I understand that, Your Honor, but
that's not how contracts work.
But the problem is,
you run you know what? That's called up and down. You take the risk and you see what happens. You vacate the premises and you wait for the landlord to sue you, and then you litigate, and that's how it goes.
But the problem is, Your Honor, is the trial court said the exact opposite.
But there was no injunction for you to move out, was there?
So, well, there was a difference of opinion.
Was there an injunction for you to move out?
No, there wasn't, Your Honor, and that's why we sought injunctive relief to try to resolve this question.
That's why I said earlier that there was no judicial injunction at all from you moving out. So you could move out without violating any court order. That's why I asked you very early on, was there an injunction? And you said
no. I understand that, Your Honor. What we felt was we needed to get a judicial resolution. But beyond that, Your Honor, since I understand the main problem here, the real problem here is that paragraph 5A requires the owner to redevelop the premises and deliver it to Prada by March of 2023. As matters now stand, the trial court has held, and it's the order up on appeal, that the owner has no such obligation, and that the remedies that Prada has under the contract are not available to Prada. Prada can't get rent credits, and it can't ultimately terminate. So Prada is left in a situation.
Mr. DeLoe, now you're just repeating your argument, and we have such a busy calendar today. It's no disrespect to you, but your time for rebuttal is really expired.
In conclusion, Your Honor, then I would just say the election of remedies was not a basis for the trial court's order. We would ask that paragraph 5A be enforced according to its terms, and on that basis, the trial court get reversed. These other issues obviously can be addressed below once that court reverses on that basic threshold contractual issue. Thank you, Your Honor.
Thank you. Thank you both. All right. Harris versus Harris.
Thank you. Tamara Harris on behalf of Appellant. Good afternoon, Your Honors. I apologize for my camera not working. The basis of this appeal is that the lower court basically threw out the complaint on the grounds that it felt that there was no breach of fiduciary duty alleged and that the respondents would be entitled to immunity. This complaint, as was my deposition, is replete with information about how they acted in bad faith. There is allegations in the complaint about how they blocked an ENT doctor, with Bernice in particular standing in front of the door screaming, "I am proxy," when my father couldn't swallow, he couldn't eat, he couldn't drink, and she barred the ENT from coming in. She extricated my private nursing staff that I paid for. She refused to give him a feeding tube, even though the plain language of the proxy expressly stated that he wanted to be kept alive as long as possible, including to be given nutrition and hydration through a feeding tube. It got to the point where a temporary restraining order was issued against Bernice. And moreover, the complaint alleges a financial bad faith motive where she's actually going to the bank 3 hours before my father died and walking out with $504,000 in cash. So
Ms. Harris, this is Justice Kennedy, and I was under the impression that the complaint only stated claims for wrongful death, pain and suffering, conversion, and unjust enrichment, and that this is really the first time that you are asserting a claim for breach of fiduciary duty on appeal, which is improper. But as I stated, this was not asserted below.
But it was, Your Honor, respectfully, although the attorney that handled the case did not underline it like he did the other causes of action. If you refer to the complaint, specifically paragraphs 42 to 45, you will see that the allegation of breach of fiduciary duty is plain as day. It alleges that they violated my father's trust under the proxy to give him life-prolonging, life-sustaining treatment. It alleges breach of fiduciary duty. The express terms are there. It alleges their misconduct in extricating the nursing staff, deprivation of the feeding tube. It also alleges denial of proper antibiotics until the issuance of a TRO. And it also alleges an injury, which is that he was cognizant on April 21 of what was going on. He was screaming in pain, asking for food and water, accusing Bernice and her daughter of trying to kill him. So there was conscious pain and suffering alleged. It also alleges, interestingly, bad faith in paragraph 43, which directly refutes the court's finding that there was immunity in this case. And the court's job, as I'm sure you're already aware, is to look at a complaint and determine if there's any cognizable claim, even when one is not stated. And that's black letter law. In this case, although it's not underlined, every single element and every single fact to support breach of fiduciary duty is clearly in that complaint. And under public health law, section 2982, it says that a healthcare agent shall, not may, not can, but shall make decisions in accordance with the principal's wish. This was an unquestionably clear healthcare proxy that my father wanted to be kept alive as long as possible. And they breached their obligations under that. And the lower court imposed an obligation on me when analyzing the breach of fiduciary duty claim, because it did do an analysis on that to prove that death was an element. And that's simply not one of the elements for breach of fiduciary duty. I need to prove breach of fiduciary duty that was breached through some kind of misconduct and some injury. But there's never been a requirement under our law that for a breach of fiduciary duty claim to be sustainable, that I need to actually prove death. But I also want to address the wrongful death element of the complaint, which is underlined and is in all capital letters. And I want to make a distinction clear. One of the things that my dad put in that proxy was, he wrote, "I want to be kept alive as long as possible!" Exclamation point. So whether that was, 2 weeks, 2 years, 2 minutes, it was my father's right, and it was his wish to be kept alive as long as possible. And one of the things Judge Ritholtz says in the Borenstein case that's cited is that any fraction of infinity has value. If someone's going to live 2 weeks, 2 minutes, 2 hours, that has value to them. The sanctity of life itself has value. And my adversaries claim, my dad had other conditions. He was septic, and that may be true. He may have been septic. I've never denied that. I've been very upfront with that. But one of the things Judge Ritholtz notes is that it's common knowledge that to keep somebody alive as long as possible, to prolong their life, you must give them food and water, even if they're comatose, through artificial means. In this case, these defendants were opposed. They were opposed to a feeding tube. They adamantly refused to give him a feeding tube. He had absolutely no chance of having his life prolonged, much less of a chance of having the antibiotics even work. And what I allege in the complaint.
Ms. Harris, you have exceeded your time. I'm going to allow you to finish your argument, and then we'll hear from the respondents, please.
Yes, if I could touch upon the turnover proceeding very briefly, Your Honor. There was never a turnover proceeding brought in the surrogate's court. And although my adversaries claim that the discovery proceeding is a predicate or precursor to the turnover, the bottom line is I have the right to elect my forum and my remedies. I elected to bring a timely conversion claim in Supreme Court, which if this court allows the dismissal to stand as being duplicative, would be time barred. I can't ever bring a turnover proceeding. Statute of limitations has run. My obligation as a nominated executor is to preserve the claims and the assets of the estate. Otherwise, I will be held liable, as respondents agree. And that is exactly what I had done when I brought that action. And the court was wrong to dismiss that as duplicative of a non-existent proceeding based on a misrepresentation by counsel. Thank you.
Thank you. All right, let's hear from the first respondent. We got Miss Harris. Miss Bernice Harris. You need to take yourself off mute, please.
So sorry. Good afternoon, Your Honors. Keith Fleischman for respondent Bernice Harris. If it pleases the court. Your Honor, this appeal should be dismissed on 3 separate grounds. First, the appellant has no standing either to have brought this appeal or to maintain this appeal. On June 19, 2019, appellate's letters were specifically revoked by the surrogate court. And thereafter, the Bronx public administrator was appointed preliminary executor of the estate until the whole.
Does she have the right to continue this proceeding as a beneficiary of the estate?
She does not, Your Honor. The law is clear in the Gaitner case that she cites that only after the estate is completely, all the disposition is done and it's over and there's no dispute as to anything. And and fundamentally, if there was no other preliminary executor appointed by the surrogate, as long as there is, she does not. The surrogate is the only one duly authorized by the court to prosecute actions and to collect assets of the estate. But even if there was no preliminary executor right now, even if Bronx County public administrator was not the public administrator right now, duly appointed by the surrogate's court, she would not have the ability. If there was none, it would have to wait until the estate was completely disposed of. Anyway.
Well, why wasn't the public administrator substituted in the case before this order came out? I mean, I'm a little confused. Shouldn't the order was in July, right? And the order, you tell me, and the public administrator was put in June. Shouldn't the public administrator have been substituted?
The public administrator, if the public administrator wanted to have anything to do with this case, the public administrator could have. The public administrator, my understanding, has been active with the estate, doesn't have anything to do, doesn't want to pursue this case, so is not pursuing this case. But the bottom line is that the appellant has no authority because there is a public administrator who is protecting and prosecuting whatever they're doing, the assets of this estate. And it was clear when the surrogate removed the appellant as the preliminary executor, said, quote, "There is no scenario of which this court can conceive that would allow this estate to move forward should the preliminary executor remain in place." And the law is clear, Your Honor, in New York and in the first and second department, that you have to be duly authorized by the surrogate court in order.
I'm going to ask you to move on to the other arguments because
yes, Your Honor.
3 minutes.
Yes, Your Honor.
As everybody can see, this is an unbelievably busy calendar.
Yes, Your Honor. So sorry. Yes, the second is that appellant has waived every single argument she makes on appeal, except 1, standing, 2, that all extrinsic evidence should be excluded, and 3, that the four corners of the complaint state a cause of action. The first department and the New York Court of Appeals is clear that if an appellant fails to raise an argument based on facts in the court below, she is specifically precluded, they are unpreserved, and she is waived those on appeal. Similarly, if an argument's not addressed, an appellant's opposition in the court below, and that's the Patel case, they are waived. And by the way, there was never a fiduciary claim brought in this case. There is no cause of action, and there just it was never brought below. She filed a seven-page motion to response to motion dismiss, which addressed absolutely none of the arguments made by the defendants. Finally, Your Honor, the court below's decision was correct and should be affirmed. It relied solely on the four corners of the complaint, finding that the complaint failed to state a cause of action for wrongful death and that no bad faith was alleged, and therefore that respondent was protected under 2986 of the public health law. The court found it impossible to ascertain, and it's clear just from a plain reading of the complaint, it's impossible to ascertain when the alleged facts happened, whether it was prior to the proxy becoming active or during it. And it's also unknown from the complaint what the decedent died of. There's no cause of death, so there's an impossibility to have any causal link. Finally, Your Honor, regarding the, and I'm wrapping up, regarding the unjust and conversion claim, you know, appellant failed to address the argument at all.
Yeah, this is, I don't understand this, though. You mean it wasn't addressed below? Okay, I mean, never mind.
Yes.
Never mind. I'm not even going to ask.
Yeah, it was never, it was never addressed below. And finally,
we understand. I thought that was finally.
This is it. This is the last finally, if I may. 2103, SPCA 2103C specifically allows for both the discovery and the turnover of specifically money in bank accounts. And there are a myriad of courts, including Matter of Hill and Dwyer v. Velachevich, which says that SCPA 2103 established a discovery procedure and a turnover procedure where a fiduciary can identify and recover assets of the estate. Your Honor, thank you very much.
You don't think there's no statute of limitations problem here?
It's not relevant. First, appellant has no standing, and no, she elected 3 months before filing the conversion and unjust enrichment claim to go to the surrogates court and file this 2103 proceeding. She's got that proceeding, but she doesn't have it. Thank you.
All right, thank you.
For all those reasons.
Let's hear from the co-respondent, Ms. Schiaffini.
Yes, thank you, Your Honor. I had a little mic issue earlier. I hope you can hear me.
We can.
Great. May it please the court, I represent the co-respondent daughter. And first, I'd just like to respond to one of your questions, Judge Gish, a little bit further. The appellant was disqualified from continuing as the estate fiduciary before the order of Judge Sherman was issued. And before those dispositive motions were decided, there was a motion also by the defendants to substitute the public administrator in the place instead of the appellant because she had already by then been disqualified. And the order from which the appeal is taken didn't reach that argument and characterized it as academic because the action had been dismissed.
Dismissed. Thank you.
So that's the procedure there. I'd just like to briefly underscore a few points that are relevant to my client. First is that there's no dispute whatsoever and there's no allegation in the complaint that my client, who was the alternative healthcare agent, was ever called upon to make any decisions on behalf of her father, because her mother, Bernice Harris, who was the primary proxy, was never unavailable and never unable to make any decisions that were required to make after the decedent was unable to direct his own care. So there's no claim that my client was ever called upon to make decisions concerning her very ill father, and she never did. So the proxy issue, as far as she was concerned, it was never activated. I'd like to also underline the appellate standing argument. And Your Honors, the history in the surrogate court is very relevant to this case for two major reasons. One is that the preliminary letters were issued to the appellant based in large measure upon her representation under oath to that court that she was uniquely qualified to serve in the fiduciary capacity of this estate because only she was willing to bring a medical malpractice action against the decedent's providers when he was literally on his deathbed in one of the most renowned facilities in New York City. She claimed in her sworn testimony that they killed him with their medical negligence. And there was a so ordered stipulation when the preliminary letters were issued, appointing her preliminary executor and permitting her to bring a medical malpractice action. She didn't bring a medical malpractice action, and one might inquire whether she ever intended to bring a malpractice action. But what she did do is she brought a wrongful death action against the decedent's lawful wife and daughter. The ship has sailed on the medical malpractice action. The statute is gone. It doesn't.
It was never brought?
No, it was never brought. And you can certainly imagine that had the intention to sue the lawful wife and daughter for wrongful death, for causing the decedent's death while he was in one of the finest hospitals in New York City, I don't think that there would have been a so-ordered stipulation authorizing such an action. So there's a certain amount of strategery at play here, I submit. But in any event, when it became clear to everyone involved that this estate could not proceed toward resolution under her guidance, the court failed and declined after due consideration with a detailed report to disqualify her from continuing. And as Mr. Fleischman pointed out, the thinking was this case will never resolve. And I would say that it was actually a kind of prescient order because we're almost at the 5-year mark from the death, and the testamentary instrument that was proffered by appellant still hasn't been probated. So there was so much unrest among the folks that the court ruled that she shouldn't remain in that place. She was removed, and the public administrator was appointed to continue as the estate fiduciary upon her removal. Now, she continued, the appellant continued.
I'm going to ask you, you only had 3 minutes again, You're way over.
I am, so sorry.
You're not the first one today who's over their time. So let's bring this to a head.
Okay.
And then we'll hear rebuttal from Ms. Harris.
So there were steps that could have been taken to bring this appeal properly. And there were 3 of them. One of them was a timely appeal from the disqualification order, perhaps with an interim stay. That didn't happen. In fact, an appeal was brought a year after the order, and this court dismissed it. There was a possibility that she could return to the surrogate court and ask for specifically limited letters solely for the purpose of prosecuting or maintaining this action and continuing this appeal, bringing this appeal. The appeal had not even been brought when she was already disqualified. And finally, she could have gone to the public administrator and said, you are now the estate fiduciary. I'm a presumptive or possible beneficiary, distributee. Why don't you bring this appeal? And there's no evidence that that was done. And it doesn't take a lot of scrutiny, I would submit respectfully, that to bring such an appeal under these circumstances, with this action having been drafted the way it was, and the dispositive motions having been essentially not even opposed, I respectfully submit that the appeal should be dismissed for no standing, and alternatively, the order of Judge Sherman should be affirmed.
Thank you. All right, Ms. Harris, you have 2 minutes.
Thank you, Judge. As I noted in my reply brief, the reason the malpractice action never went forward, despite a very reputable law firm submitting an affidavit in front of the surrogate court, was because the blood bag at issue came from an independent blood lab, and anaplasma in particularly is a pathogen that in 2017 was not mandated to be screened for. So although a law firm did submit an affidavit, and I did hire a law firm for that purpose, that is the only reason the malpractice did not go through. But the fact that there may or may not have been malpractice does not mean that these respondents don't have to comply with the express language of a proxy. I mean, they were still burdened to provide life-saving or life-prolonging treatment, and they don't dispute that they violated the terms of that proxy and failed to provide that treatment. On the issue of standing, as my adversaries have admitted, the Bronx public administrator has had no interest in pursuing this case. And as a practical matter, the reason they have no interest is because the law firm they retained has no prospect of being paid, because Bernice depleted all of the bank accounts in a series of deathbed withdrawals, walking out with $504,000 cash 3 hours before my dad died, and another $500,000 before that. In terms of standing, and there's cases cited in my brief, when a public administrator or somebody appointed by the court has no interest in pursuing a case under EPTL 11-1.3, even before a will is probated, the nominated executor has the right and standing to commence an action aimed at preserving the assets of the estate. And that's exactly what I did, especially when the administrator, by everyone's admission, has no interest, because it's an unfunded estate, in pursuing any of these actions. I do have standing based on that, and based on the fact that I'm a nominated executor under the will. I don't get my powers, as I state in my brief, from the letters of the court. I get it from the will itself. And the problem with the let's see and wait approach that's being—
I don't understand that.
Here's
I don't understand it. Even when you're nominated as an executor or a representative under the will, you have to get letters to act. That's just basic estate law.
Well, actually,
I don't understand.
Under EPT, under the EPTL, even before a will is probated and even before letters are issued.
Yeah, but that's a different circumstances. Here you got the letters and then they were revoked. And that doesn't mean you can just willy-nilly say, well, I have a will that appoints me and therefore I'm entitled to act. I think you're misreading the statute, but I'll look at it again and your time is up. Thank you all.
Your Honor, can I say one thing?
No, we're done. We're done. We have your briefs and your very passionate arguments. Believe me, we're familiar with them. Thank you. Thank you all.
Thank you.
Thank you, Your Honor.
People versus Lindsay's.
Good afternoon, Your Honor, and may it please the court. My name is Amelia King-Musa, and I represent Appellant Nevin Lindsay. I will be very brief. I just want to say a few words on the right to the conflict-free counsel issue. The Court of Appeals has made it manifestly clear that a conflict of interest arises when counsel takes a position adverse to his client. And counsel takes a position adverse to his client when stating that defendant's motion lacks merit. That's all it takes. The Court of Appeals said this in People v. Mitchell in 2013 and People v. Washington in 2015. Now, this is a hardline rule. And
counsel, are you referring to the motion to set aside the verdict as against the weight of the evidence? Is that what you're referring to?
That's one of the many things here where counsel took a position adverse to his client.
But statement of counsel came after the motion had already been decided.
Right. And that was one of the many times that counsel took a position adverse to his client. This manifest conflict of interest was apparent even at voir dire when Mr. Lindsay first brought up these issues, and when Mr. Lindsay started discussing his predicate felony status. At that point, counsel was already saying, I disagree with Mr. Lindsay, he's incorrect. And that is a conflict of interest. And even
but was counsel wrong that Mr. Lindsay was incorrect? That there were whatever conviction it was that he was referring to had not been reversed?
Quite frankly, Your Honor.
Was not that in answer to a question from the court?
So, Your Honor, when defense counsel believes that a client's pro se motion is meritless, the Court of Appeals has said that the proper course of action is to, quote, make no comment, end quote. Even if the motion is meritless, the most that counsel can do is simply, say I did research or something like that. But even just saying there's no legal basis or I disagree, that is at that point taking a position adverse to their client. And at that point, there's a conflict of interest. And this happens again and again throughout voir dire and at sentencing. And because this happens throughout the whole trial proceedings, it's very clear that Mr. Lindsay was deprived of his right to conflict-free counsel. And if there are no further questions at this moment, I will just reserve the rest of my time for rebuttal.
Any questions, counselors? Colleagues? Thank you. All right, let's hear from the people.
Good afternoon, and may it please the court. David Gagne for the people. This court should affirm defendant's conviction because the evidence clearly established his intent to steal the merchandise, and because at no point during the proceedings did defense counsel's comments create a conflict entitling defendant to the sua sponte appointment of new counsel. And I will jump straight to the ineffective assistance claim. I want to emphasize that on voir dire, the only matter pending before the court was whether to grant the defendant's stay of proceedings. The defendant said that his counsel had been ineffective because he had not completed all the discovery he had asked for. And so defense counsel's comments were in direct response to those comments. And this court and the Court of Appeals has held numerous times that a defense counsel may respond to complaints about their performance. When it comes to the statements that were made at sentencing, I would just like to clarify an issue. In People v. Mitchell, which is cited by the defense in their brief and is raised again today, the court did not consider whether a motion that was patently meritless, whether a defense counsel's comments that they didn't agree with that motion, whether that created a conflict entitling the defendant to new counsel. In fact, that is not what Mitchell said. And in at least 3 cases cited in my brief, this department has held that when a defense counsel simply states that there's no legal basis for a motion that is patently meritless, which is clearly the case here, as defendant does not even contest on appeal that there was any merit to his motion challenging his predicate status. When that is the case, that does not invariably create a conflict entitling the defendant to new counsel.
Counsel, just a quick question. Did the defendant ever request substitute counsel here?
No, Your Honor. The defendant did not at any point in the proceeding specifically request new counsel. He did make complaints about his counsel on the eve of trial, but he never said that he was seeking new counsel. And if there are no other questions, I would just ask that you affirm.
Thank you. All right, we're going to hear rebuttal.
Counselors, excuse me, oh my gosh. Justices, I'm so sorry. I'm making the same mistake.
Go ahead. One of those afternoons. Go ahead.
So first, just addressing my adversary's point that they cited multiple cases from this department, kind of in this same situation where there was allegedly a meritless pro se motion. Those cases were actually not in the same procedural posture at all. In People v. Taylor and People v. Clemens, the court had actually already appointed new counsel to avoid this specific conflict of interest already. And in People v. Maxwell, there was no specific motion or request. There were simply just generalized complaints from the defendant. So there was no need to do this inquiry about conflict of interest because there was no specific request or motion. However, sister courts in the second department in 2018 found that the simple phrase, quote, "I don't think it's correct," was enough for defense counsel to be taking a position adverse to their client. That is People v. Fair in second department in 2018, and the third department, People v. McCrae, counsel stating that there was, quote, no legal basis for the motion was also enough to be taking a position adverse to their client. So it really is the proper course of action, as the Court of Appeals has said, to make no comment about the merits or lack thereof of a pro se motion. And the defense counsel's actions in this case go far beyond defending their own performance. For that reason, we ask this court to reverse and remand for a new trial. Thank you, Your Honors.
Thank you. Thank you both. Nazaro versus Mount Sinai. Okay, this is multi-party, so let's organize this. All right, we'll start with the first appellant, and let's make that Dr. Klein for Daniel Klein. Go ahead.
That would be me. Good afternoon, Your Honors. May it please the court. Dr. Klein's expert on the summary judgment motion laid out that plaintiff's blood pressure was appropriately maintained throughout her stay at DeWitt and that she did not require any antihypertensive medication. Plaintiff's entire case is essentially that antihypertensive medications should have been prescribed because her blood pressure was high. Plaintiff's expert's assumption that the blood pressure was high is entirely based on a clear misreading of the record. In fact, plaintiff's expert from the get-go notes that while daily blood pressure checks were properly ordered on August 20th, they were, I believe the language is, inexplicably discontinued on August 25th. Looking at the chart itself, the expert took the discontinued date from another completely unrelated order and applied it to the blood pressure checks. In fact, the blood pressure checks were ordered to go from August 20th up until sometime in September, but were discontinued on August 31st when the decedent died. Furthermore, the treatment administration records in the DeWitt chart note that blood pressures were taken absolutely every day. I believe there's one day where the notation was missing on August 25th, but essentially they record that blood pressure checks were taken every day. Blood pressure values were only recorded on the first 3.5 days by the nurses, and then a few days later by Dr. Klein. And the director of nursing at the home issued a sworn statement that the nursing home practice is to basically record blood pressure values only for the first 3 days, and then after only if there's a clinically significant change in the blood pressure. Taking that together, the record essentially establishes that blood pressure was taken daily, that the blood pressure was in a normal range. This entirely undercuts the plaintiff's entire theory that antihypertensive medication should have been prescribed. The plaintiff's expert's reading entirely ignores the affidavit of the nursing director. And again, the only affirmative piece of evidence that he puts forth to support his opinion that blood pressure checks were not taken daily and that there may have been elevated blood pressure is this mashup of two orders and an entire misreading of the discontinuance of the end of the daily blood pressure checks. As a second matter, as to Dr. Klein and the nurse Silverstein, they both testified what their duties were at the nursing home. The plaintiff alleges that Dr. Klein and his employees should have made sure that the nursing home followed their orders every single day. Dr. Klein and Nurse Silverstein were not at the nursing home every single day. This is a common arrangement at nursing homes. If nursing homes had in-house physicians, the cost of nursing homes would not be attainable for many individuals. Rather, they intake patients, and then when they're called upon by the nursing staff, come and evaluate the patients as needed. This was their testimony. Plaintiff's expert opined to the contrary, but duty is a question of law. It's really not for an expert to opine on, and the court below also erred in finding a question of fact as to whether or not Dr. Klein had a duty to enforce the orders issued by him and his employees.
Okay.
If the court has
Thank you.
no further questions,
Yeah.
then we'll rest on our briefs.
Okay, and we're going to move on. I neglected to say at the beginning of this argument that Justice Shulman has recused himself. And in fact, he's absented himself from the argument. So it is the 4 remaining judges on the panel who are going to decide this case. Let's hear from the next appellant, for Ms. Silverstein.
Good afternoon, Your Honor. May it please the court, my name is Robert Martin, and I'm pleased to be here on behalf of Nurse Practitioner Silverstein. And I appreciate the arguments advanced by Eldar Mehus on behalf of Dr. Klein. Nurse Practitioner Silverstein was with Dr. Klein's practice. She was not an employee of DeWitt, and she was there. Her duties were circumscribed. She saw the patient one day only. The first full day of admission, August 21 of 2013. The night before, the patient was actually seen by a physician, Dr. Ferreter. Counsel for the plaintiff respondent does not dispute that it was reasonable in the first instance to rely upon the transfer documents from the hospital, which, among other things, provided no antihypertensive medication for this patient who had suffered an MCA stroke, and therefore Nurse Practitioner Silverstein properly relied upon those records, properly rendered an assessment, and because she acknowledged she was aware of a prior history of hypertension, although there was no active hypertension at the time, ordered blood pressure checks every day for 30 days. And in fact, one can look at her order, which is typed and printed in the record at page 3808. It shows that the blood pressure checks were ordered, blood pressure and pulse, for 30 days, electronically signed by Nurse Practitioner Silverstein. And they went on to the patient's discharge on August 31st. And in fact, this
is Judge Giss. I have a question. Sure. There's some issue raised about whether Nurse Practitioner Silverstein, upon admission, there's some question about the blood pressure that she recorded during the admission. Can you address that for me, please?
Absolutely, absolutely. The blood pressure that was noted on August 21st in the chart clearly is 135/70. Through the benefits of technology, because it was a handwritten note, if you blow it up, you will see that there is on the line where it says the 135/70, the shape of the 3, basically 2 half circles, is clearly there on the 3. If you look earlier on the same line, there is a 9. It is an oval with a stick. That was the handwriting of the 9. Plaintiff's expert keeps on wanting to call this 135. He is the only one that is referring to this as a 135, just because this person.
You mean the plaintiff's expert said it was 195?
Correct. Sorry.
Right, because 135 would be within the normal range. It wouldn't require medication.
Correct. And that's why if you blow up, if you look even at non-blown up, you can see what looks like a 3 and you compare it to the other 3s on the page. It looks like a 3, but plaintiff's expert wants to call it 195. And just because this expert wants to say it's so doesn't make it so. When you compare it to the other numbers, I asked the court to take judicial notice of this fact and look, and I invite the court to look at the entire page, blow it up, look at the entire page. Again, the Sipsey-Dixit statement that plaintiff's counsel wants to carry through and that plaintiff's expert wants to carry through, which is the basis of the claim, that there is a recorded high blood pressure. It's inconsistent with everything else from the final days of, and most of the time at Mount Sinai, and the entire time at DeWitt. And pointing out at page 3858 of the record, the nurses initialed every day except for the 25th for whatever reason. Dr. Klein saw the patient on the 26th and ratified the treatment plan.
and there was a change in condition on the 31st involving a precipitous, a change in mental state. And then when she gets to the hospital, there was a precipitous drop in blood pressure, not an increase, but a drop in blood pressure, which heralded this change in condition. And again,
I'm going to ask you, and I know I've
Sure.
given you all very short times, but there's so many people arguing. And,
Fair
you know, if you could just bring it to a conclusion, Mr. Martin, please.
Absolutely, Your Honor, and thank you, Your Honor. The records show Nurse Silverstein, contrary to the allegation, did not discontinue the daily blood pressure checks. Far from it. The order record is clear. She did not. The record demonstrates, and the proof demonstrates, why it was not a departure for her to overrule the discontinuing of antihypertensive medication from Mount Sinai, where she was treated for the stroke. And plaintiff has not set forth a basis for a duty for a nurse practitioner, Silverstein, an employee of Dr. Klein, to police and oversee the day-to-day tasks of the nurses at the facility who noted they saw the patient every day, followed the rules set forth by the nursing administrator, and therefore, for the remainder, I wish to rely upon our brief and respectfully request that this court reverse the decision below and grant summary judgment on behalf of Nurse Practitioner Silverstein. Thank you all.
Thank you. All right, now we're here from Appellant DeWitt.
Yes, good afternoon, Your Honors. May it please the court. Anthony DiStefano for the appellant DeWitt. So as my colleagues have laid out, DeWitt did in fact monitor the decedent's blood pressure during her stay at DeWitt. And that is page 3858 of the record, which demonstrates that every day except for August 25th, they did take her blood pressure. Now, Nurse Silverstein testified that the order for monitoring blood pressure was to make sure that it was in a range that they would expect. So as my colleagues again pointed out, the assistant director of nursing gave an affidavit which explained that that range is established during the first 3 days of admission where blood pressure values are recorded. And here they were between 120/70 and 140/70. So for the remainder of that period, as long as the blood pressure values were within those ranges, there was no need for the nurses to document specific values in the nursing progress notes. So here we have, after the 3 days, the nurses did check blood pressure, and we have no clinically significant changes after that point. So all they do is they initial the record that blood pressure was in fact taken. Now, to further answer Justice Gish's question about the 195, Dr. Klein was asked during his deposition to take a look at that note, and he said, he was asked, what does the blood pressure reading on that note say? And he very clearly testifies 135/70. So Dr. Klein had no problem reading that note and seeing the 135 there, not the 195. Our expert, Dr. Merkler, also gave an opinion, and he attested that it was not possible for the plaintiff, for the decedent here, to have been 137/60 at Mount Sinai when she was discharged, to be elevated to 195/70 when she is admitted at DeWitt, to return to 140/70 the next morning without any intervention. Here, as my colleagues have pointed out, the transfer orders from Mount Sinai did not follow through on hypertensive medication for the decedent, so none was given. So here, without any intervention, it would be impossible for blood pressure to go from 137 to 195 and then back to 140 again without that intervention. So again, further establishing that it is in fact 135 that is recorded at DeWitt upon admission. The other allegation against DeWitt is that it failed to intervene when the decedent was complaining of lower back pain, and that the lower back pain may have caused a spike in blood pressure. Now, both Dr. Klein and the expert Dr. Merkler stated that the level of pain that you would have to experience to cause a spike in blood pressure is so extreme that it would be near life-threatening pain. And here there is no evidence in the medical records of life-threatening pain. What we have is during the 24th and the 25th, complaints of pain for which ibuprofen was given, and the decedent responded well to the ibuprofen, and it relieved her pain. And in fact, at that time, she was examined by Dr. Klein, and her blood pressure was recorded at 135/70. So it was still stable, even though she was undergoing this pain. Now, on the morning of the incident, she complained again of pain and she wanted the ibuprofen, but that's when the incident occurs. That's when she suffers the hemorrhagic stroke. And unfortunately, that is what leads to her demise. But there's no indication that she was experiencing the type of pain that would have elevated her blood pressure to such an extent that it would have caused another CVA stroke. So that leads our expert again to conclude, wrapping everything up, that a hemorrhagic stroke is based upon a long-standing period of uncontrolled hypertension. It cannot be uncontrolled hypertension of just a week. And that's not really addressed by the plaintiff's expert in opposition to the motion. And here we have testimony and we have evidence in the records that the decedent did have long-standing uncontrolled hypertension. She had 4 years of not taking medications for hypertension, and which is what our expert opines led to the hemorrhagic stroke that ultimately led to her demise. So for all these reasons, we respectfully ask that the complaint against DeWitt be dismissed in its entirety.
Thank you. All right, now let's hear from cross appellant Nazario.
Yes. Good afternoon. May it please the court. First question, am I only talking about the cross appeal for Mount Sinai, or am I giving you my response?
This is you got extra minutes from everybody else. You are taking it for everything.
Okay.
You get a little rebuttal after that, but you know, you don't get separate argument time. This case already it's getting cumulatively more time than anything else on the calendar today. So use your time wisely.
So first I'll start with all the arguments that were made. First, as to nurse practitioner Silverstein, she didn't even make out a prima facie case. Dr. Goldberg's affidavit is so woefully insufficient and has absolutely no facts or anything which it's based upon. It's a few paragraphs saying she did nothing wrong, so she needs summary judgment. That's just absolutely insufficient. I disagree about counsel's handwriting analysis. Our expert, and including us and the nurse, they also 195/70. If they have a disagreement as to that, then that's a question of fact. Interestingly, none of the defendants provided an affidavit of the person who authored the note that's on page 3828, where we say it says 195/70. So, any one of the defendants could have tried to get in touch with that nurse and gotten an affidavit, but none of them did.
Is there anything in the record regarding the argument made here about the impossibility of it being 195, given the temporal proximity to blood pressures taken in a normal range, both before and after?
Sure. Dr. Klein, some of the experts, and our expert says that blood pressure is labial. It varies during the day. And depending on when Ms. Nazario was experiencing her back pain, and when they took the blood pressure, whether it was after she was given the ibuprofen and the acetaminophen, or if it was before, that would affect her blood pressure. They all say that it varies throughout the day. So a 9-hour change from one to the next, that's pretty long. That's not a short period of time. And she could have had the, medication for the pain. It could have just been the time that passed. So there's really nothing in the record to establish that blood pressure can't change. Everybody says quite the opposite. In fact, Dr. Klein's expert, Dr. Garbatelli, actually says her blood pressure was 155/70. So there's a third opinion as to what her blood pressure was. He says that at A4070. So we have yet another, opinion of what the blood pressure was. Now, Dr. Klein also says that his I'm sorry, I can't hear you.
I think Justice Mendez has a question. We're having trouble hearing you, Justice Mendez. We are having beyond technical problems today on every level. If you want, you could text me your question. I'll ask it. They can see you and they can hear me.
Right. I'm sorry, I can't hear it. No. Okay. Dr. Klein did say at his deposition that it was his obligation to make sure that medically you know, the patient gets her medication, laboratory tests are done, and that, you know, everything be reviewed and the patient be evaluated. Well, if blood pressure was actually taken, which we disagree with, and a box was just checked, how can any physician evaluate what her blood pressure was with no indication anywhere written of what it was? I mean, we have a 195/70. Dr. Garbatelli has 155/70. Was the blood pressure taken after she was given pain medication? That we don't know. As to DeWitt Rehabilitation, their director of nursing's affidavit is not only self-serving, but it specifically says for patients admitted for long-term rehabilitation. This was short-term subacute rehabilitation. She was not there for long-term treatment. So everybody's reliance on this one affidavit, this director of nursing saying what the procedure is for patients admitted long-term doesn't apply to Ms. Nazario. Ms. Cruz. So it's everybody's relying on a standard of care that wasn't for the plaintiff. So it makes all of the affidavits submitted by defendants without basis for their arguments of the fact that they only did nursing notes for the first 3 days. And as our nursing said, monitoring a patient's blood pressure without recording it is pointless because doctors have to see trends over time and they watch trends of things as they go.
Ms. Quessia, your time has just run out. I know you haven't addressed Mount Sinai. I'll give you another minute to address that, to turn to that now.
Thank you so much. I'm sorry. Okay. Now, Mount Sinai also didn't meet their prima facie burden because their experts all have the mistaken assumption that the order for losartan was intentionally discontinued, and there was no intentional discontinuance. Dr. Carafin said he didn't discontinue it. Dr. Avolio said he didn't discontinue it. And there was no other doctor at Mount Sinai who saw her. And our expert explained why you don't discontinue a patient's blood pressure medication to see how she does and then discharge her the very next day so that you can't ever monitor how she does without the medication. This medication was necessary exactly to prevent the hemorrhagic stroke that happened to Ms. Cruz 11 days later. Short and sweet.
Okay, thank you. All right, Mount Sinai, 4 minutes.
Muted.
We can't hear you. You're on mute.
I apologize. I was trying to keep quiet during everybody else's presentation.
We appreciate it. Go
My
ahead.
name is Gina Bernardi DeFalco. I'm here for Mount Sinai and the two doctors, Dr. Avolio and Dr. Carafin. So the plaintiff's presentation today is the red herring in the argument that this wasn't an intentional discontinuance. The order is written by Dr. Carafin with an expiration date. So while Dr. Carafin was asked the question, did you discontinue? His answer was no, because he didn't write an order to discontinue it, but it had an expiration date. And Dr. Avolio was gone. He didn't see the patient again after the 16th, and this expiration was on the 18th, and the patient was discharged on the 20th. Be that as it may, the entire premise behind the plaintiff's theory in this case against everybody is that you should have given antihypertensives to a patient who was not hypertense, which makes absolutely no sense. Yes, she came in with this infarct, this clot, stroke, with a history of 4 years of hypertension. While she was at Mount Sinai, they were working with the blood pressure. First, it was kept controlled high outside of the normal range because that was necessary when you have a clot to make sure the blood keeps pumping through. And then it was brought under control. And then it was discontinued to see what would happen. Yes, she was uncontrolled when she came in. She wasn't on meds when she came in, but how she was 4 years before she had the stroke is not what you clinically consider. It's how she was at the time the order expired. Now, also, I hear everybody from my co-defendants say the entire time she was at DeWitt, she was monitored every day. Her blood pressure never spiked. This issue about whether it was 135 or 195 on admission, I think it's pretty clear if you read it, it's 135. And despite what Ms. Kasha said about everybody testifying that blood pressure can be labial, no one from the plaintiff, including their expert, addressed the idea that it couldn't fluctuate that much. Someone had an expert that said it couldn't fluctuate that much and then be back to normal the next day and be normal when she left Mount Sinai, and their expert did not address that. There is also a proximate cause issue in this case. I had a stroke expert. Plaintiff's expert is not a neurologist, not a stroke expert. He's a critical care expert who looked at the films and said this little amount of blood that you see on the films is not enough to have killed this patient. It's a tiny little amount of blood. It's 2 cc's. Granted, he said the plaintiff's theory that this was a hemorrhagic stroke is based on a misreading of the records at Lenox Hill. So for her to come back and reply and cite the records at Lenox Hill really doesn't address my expert's very specific opinion about the films. I understand that DeWitt has an expert neurologist who says this was a hemorrhagic stroke, but even he knocks out proximate cause because he says if these weakened blood vessels were from 4 years of untreated hypertension, not from being normotensive from the time she had the infarct to the time she died. And none of that is addressed by the plaintiff's expert. All he said was the blood pressure must have spiked with no evidence that it ever spiked. This must have been a hemorrhagic stroke that killed her. Even if it were a hemorrhagic stroke that killed her, it hasn't been linked to anything that any of the defendants did, but certainly not Mount Sinai, where she left on the 20th, and this didn't occur until the 31st, where she was squarely under the care of the nursing home. Yes, we didn't send her over there with antihypertensives, but I'm certain that if her blood pressure had spiked, they would have prescribed the antihypertensives. And if there's no questions from the bench, I'm just going to rest on the brief.
Thank you. All right, we're going to turn to rebuttal. We're going to go through it quickly. All right, the first appellant, Dr. Klein, you have a minute. You're on mute.
Thank you. Very quickly, even disregarding the Assistant Director of Nursing's affirmation, we still have blood pressures. If you go back to the time at Beth Israel and count up to Dr. Klein's measurement on 8/26, we have over a week of absolutely stable pressures. The fact that she was hypertensive 4 years prior does absolutely nothing to rebut the presumption that she maintained the stable blood pressure throughout the time. Finally, in terms of Dr. Klein testifying that it's obligation to care for the patient medically, yes, but it's not his obligation to be at the nursing home and monitor the nurses. When the nurses at the nursing home call him and tell him there's an issue, it's his job to take care of it. Again, if nursing homes had in-house physicians, the prices of nursing homes would be astronomical compared to what they are now. That is just simply not the arrangement. And I will cut it here and allow other people their time. Thank you.
Thank you. All right, Ms. Silverstein or the attorney, go ahead.
Fair enough. Thank you, Your Honor. Good afternoon. I'll also endeavor to be brief. Realize it's been a long day. With regard to the affirmation by Dr. Goldberg, it's not the quantity, but the quality, and the simple issue is this. The window of involvement of nurse practitioner Silverstein was limited, and he addressed that window specifically. She rendered one assessment, one day, carried forward the orders, and did not see the patient again, was never called to see the patient again, and the nurses saw the patient every day. And indeed, according to the record that they had there, specific initials, checked blood pressure and pulse every day. Dr. Klein saw the patient on August 26th, recorded vitals, did not change that. It is not the duty of Nurse Silverstein to supervise when she's not there or at any time. The staff of DeWitt, she testified she presumed they did their job. She had no reason to disbelieve that they would do their job. And with regard, and also, we adopted the affidavits of the affirmation of Dr. Meckler and the affidavits of Nurse Frumenti with regard to practices. Lastly, I am looking at the page 3828 of the chart at 400%. The numbers are as clear as day to me. I invite the court to do the same thing. I would share it, but I can't, obviously. Otherwise, I rest on my brief, and thank you for your consideration. We request that you reverse the court below and grant summary judgment on behalf of Nurse Practitioner Silverstein dismissing the complaint against her. Thank you.
Thank you. Rebuttal for DeWitt.
Yes, Your Honor. So on page 4136 of the appendix, paragraph 3, the Assistant Director of Nursing stated the general practice, the common practice of DeWitt at the time in 2013 when Ms. Cruz was a patient was to generate notes for the first 3 days of the patient's admission, recording blood pressure values. So that's what was done here, and that was what Ms. Lamore attested was the common practice at that time. And to address the issue of values and trends, that's what, again, the purpose of the first 3 days was. It was to find the trend, and the trend here was between 120 and 140 over 70. And as long as Ms. Cruz stayed between 120 and 140 over 70, there was no clinically significant deviation that warranted further intervention. So we know from the initials that blood pressure was recorded each day, that it would have remained within the 120 to the 140 range, and therefore did not require further intervention. And for those reasons, again, and for other reasons in our brief, we request that the complaint against DeWitt be dismissed. Thank you.
Thank you. Rebuttal, finally, from the plaintiff. Go ahead, you have 2 minutes.
Okay. First, nobody ever said that it had to be one or the other when it comes to having longstanding hypertension or 1 week of hypertension. Things can have a cumulative effect. So nobody said it was the 1 week alone. It was the 1 week given her pre-existing history of having a longstanding hypertension that then caused the hemorrhagic stroke. As to the hospital's assertion that we didn't address Dr. Mitchell Elkind's theory of why Ms. Cruz died, our expert specifically did it. Paragraph 55 of his affirmation, which is page 454 of the record. And the assertion that Ms. Cruz's blood pressure was stable while she was in the hospital, well, that was because she was on the losartan while she was in the hospital. That's why it was stable then. Not taking her off, taking her off of it is what made it unstable. That's all I wanted to address. I'll rest on my brief at this point and just request that the appellate division reverse the lower court as to Mount Sinai, Dr. Avolio, and Dr. Carafin, and otherwise affirm the lower court's decision. Thank you.
All right, thank you. Thank you all. It was a marathon argument. Thank you.
Thank you. Thank you, Robert.
Okay, the next case is Brown Rudnick versus B. Riley Financial.
Good afternoon, Your Honors. May it please the court, Eamon O'Kelly for the appellant B. Riley Financial, and I'd like to move the court to permit Richard Robbins out of state counsel to argue pro hac vice, consistent with our pro hac vice papers, which have been approved by the clerk's office.
It's granted. Go ahead, Mr. Robbins.
Thank you, Your Honor. My name is Richard Robbins, and let me first ask, I understood that the court normally adjourns at 5 o'clock. I'm happy to have this case moved to a later calendar.
No,
Go ahead.
No.
Okay.
I would tell you if we were doing that,
Okay.
no, we need to get our work done.
And I appreciate that. I'm always sensitive to judges' calendars.
Not as much as we are.
We represent B. Riley, which is a New York financial services firm. And this appeal is from the grant of a motion to dismiss our counterclaims. One, which was a multi-count counterclaim, essentially for malpractice, and another for what the trial court called a, quote, brazen breach of the tolling agreement between the parties. This case is not.
This is Judge Owing. I have a question to ask you.
Yes, Your Honor.
You missed this whole dispute. The problem here was that the investors missed a deadline date, right? A drop dead date to put in money or to extend the time, right?
Not just the investors, the buyer,
everyone,
the seller, and we're more than an. Yes, right. We had contracts, and everybody involved missed the contractual deadline.
Right, and so that your counterclaims are against your law firm, not the investor's law firm, but your law firm, because you guys are the bankers, right? I think you guys are the bankers in this.
Well, we were, I'm not sure who you're talking about, investors. We were party to several of the merger-related documents. We had a guarantee We had a commitment letter,
Okay,
et
fine.
cetera, et cetera.
Let's just strip
And-
everything. Let me get right to the heart of it. You're
Yes.
going after your counterclaims against your law firm is that they didn't tell you, or they did not alert you or remind you that the drop dead date was coming.
Well, it's more than that, but
What else
effectively,
is there?
well, this law firm was hired after the merger. They did the merger agreement, and they were well aware of the dates. And then
Were you aware of the date?
we were during the negotiation, but clearly not later in the day when the closing needed to be extended.
So you did not know. So you are telling me now that there is record evidence that indicates that your clients did not know of the date that needed that of the date certain, that you were unaware of that date certain.
Your Honor, what I am telling you is we clearly knew that, as well as 20 other deadlines when we were doing the merger agreement.
Okay.
Several months later, we hired Brown Rudnick after the merger agreement to make sure nothing fell through the cracks. They were retained at that point to monitor proceedings, to check the merger agreement, which they did something like 54 times, while we focused on financing, and they would tell us what we needed to do and when. That was their job.
I thought there was something in the record. Maybe I'm mistaken because we have so many appeals that Brown Rudnick actually sent you, or at least reminders that there was a date coming up that you had to be aware of.
No, the trial judge incorrectly stated in her order that we were made aware of that many times. All of those communications, 100% of those communications were during the negotiation of the contract, and it definitely was discussed there. Later, months down the road, we're focused on what we do, financing, et cetera, et cetera. The law firm is supposed to do what any deal law firm does, which is keep track of deadlines and make sure we don't drop the ball on anything. Wrote us and said, the closing is going to be delayed to 2019. Everything's fine. But they did not say, we need to make sure that we tell everybody we have to get an extension done.
How much, let me ask you this question, counsel. This is something that's been on my mind. How much was this whole deal worth? In the millions, right? We're talking a lot of money here, millions of dollars, right? So what I'm getting at, let me get at this thing. It really boggles my mind that when you're dealing with so many millions of dollars, that there is nobody on your side watching the date. And that you're relying only on the lawyers to tell you of the date. That to me is like, I don't know what to call it, but wow.
It has boggled the minds of every court, particularly when you have law firms of the reputation and quality of the buyer's law firm, Wilson Sonsini, and the reputation and quality of our law firm, Brown Rudnick, which charge for the period of monitoring to make sure nothing fell through the cracks. It's in the counterclaim. $900,000, 988 hours, 24 timekeepers.
Counsel, my response to that is, how much money were you going to make out of the deal?
A lot of money, and that's why we're focused on closing the deal.
Okay.
And that's why we hired a law firm to monitor the contract, who was familiar with it, and tell us what we needed to do and when.
Mr. Robbins, this is Judge Shulman. Just to pick up on what Justice Thorning was asking you, didn't Brown Rudnick clearly before the deadline tell you that the FTC approval, which was critical to this merger, would not occur before the deadline? Correct?
No,
and
no.
They made it very clear.
They said it wouldn't happen until 2019.
Right, which was after, which means that in order for you to get FTC approval to make this work, you had to extend the deadline contractually, which was Vintage's obligation, not your lawyers, correct?
Well, we had
yes or no? Was it Vintage's obligation?
Vintage's obligation.
Correct. And but they made it very clear to you, as Justice Thorne said, the banker or the person that put this merger deal together, that this wasn't happening before, and that you really need to talk to your people, to your other contracting party, and get this extension.
No, none of that happened, Your Honor. None of that happened. What they said was the deal was going to close in 2019, not in 2018. They didn't tell us anything about the deadline. They told us nothing about it, even though that was their job.
This is Judge Gish. I don't understand. I mean, if you see that the dates are not going to mesh, I mean, you're sophisticated business people. You're like, oh my God, we know that it's supposed to close on date X. It's not going to close till we're not going to have what we need to close till after that. You mean to tell me you needed somebody to tell you that you needed to get a new closing date, an extended closing date?
Well,
it's so strange to me.
Well, it's an extensive contract. We assumed that we were paying for the law firm to tell us exactly what needed to be done and by whom. And when telling us it's not going to close to 2019, at that point, we're not aware of what Vintage had done. We are doing our job. We're closing in 2019.
You had no control over Vintage and whether they extended it or not. It was their obligation, wasn't it? You didn't have contractual you didn't have any, I mean, maybe you had financial leverage over them, but you didn't have a contractual leverage over them to get them to exercise what would have been the right to extend the contract.
That is accurate. There's no question in the record or anywhere else that Vintage very, very much wanted this to close. It was a matter of moving to 2019. Your Honors, let me make one fundamental point. All that you're discussing really is a matter of comparative negligence. That's how it should come up.
There's no such thing in malpractice, though.
Yes, there is. Yes, there is.
Not in New York.
Yes, there is, Your Honor. There are multiple cases. We cited them in our brief.
We do not. When you are suing for legal malpractice,
and
there
negligence.
is no such thing. I will look at the cases you have in your brief, but quite frankly, you may as well talk to your New York counsel about that. But honestly, we'll look at it. In the meantime, your time is up. I want to hear from your opposing counsel.
Good evening, Your Honors. Can't remember the last time I got to say that. My name is Howard Ellman. I am introducing.
Nothing to be proud of.
Yeah, well, we appreciate the panel hanging in there and taking so much time with everybody else. Your Honors, let me introduce my colleague Mark Drooks, who was admitted below pro hoc vice and who's.
He can go. He can start. Come on, let's not waste time. You know, but again, perhaps New York counsel should be in on this issue of whether there's such a thing as comparative negligence in a malpractice case. Go ahead.
Thank you. It's clear from your questioning that the court has picked up on the core facts here. B. Riley was not a party or a third-party beneficiary to this merger agreement. The end date provision was clear. The complaint actually alleges that it was clear.
No, counsel, this is Judge Owing. So that it's just building on what the questions that we've asked. I mean, Vintage could have just walked away from this deal and that would have been it. I mean, whatever they did, they were controlling everything. So at the end of the day, if they missed the deadline, they missed the deadline. Then B. Riley can go after them, I guess, in that sense, right?
Absolutely. And in fact, it was even a little bit more complicated and tactical than that. Because if either party elected not to extend the deadline, it didn't immediately terminate the deal. It allowed the parties to continue to do the deal. Just it didn't oblige them to do the deal. So there was potentially an element of gamesmanship in whether to extend the end date. But we have.
What's your response, counsel? What's your response to the appellant's argument that Brown Rudnick had to be every step of the way to tell us about all the dates that were on the horizon? They had absolute They had the absolute duty to remind us, to tell us. What's your response to that?
Well, look, my first response is that it's inconsistent with the several New York appellate cases that hold that it is not the duty of a lawyer to even advise a client as to the meaning of a contract provision. Even more so where that contract provision, where that client says in his complaint that he is highly sophisticated, and a fortiori, where the client is not a party to the contract at issue, has no rights under the provision at issue, and is not even entitled to notice as to whether or not that provision has been exercised. Those cases, stepping back, make clear that the courts are concerned with creating amorphous duties as the minimum level of what a lawyer must reach to avoid malpractice. But here, what B. Riley is arguing is that the lawyer for the lender to a deal has a duty to, quote, bring the deal to closure and make sure that all the parties to the deal are doing everything that they need to do, even where those parties are represented by their own nationally prominent merger lawyers. It completely flies in the face of the notion that lawyers should stay in their lane in a deal like this and deal with their own knitting. I do, if there are no questions right at this point, I'd like to turn to what I would consider a substantial pivot in B. Riley's briefing. The accusation that Brown-Rudnick did not fail to remind, but in some way affirmatively misled B. Riley as to whether or not the end date had been extended. I'd like to spend some time on that because it really wasn't argued below at all. It was alluded to in the appellant's opening brief, but it really wasn't fully argued until the reply papers. And what I would like to point out is that it doesn't appear in the cross complaint in any sense. The overall accusation leveled against B. Riley in this counterclaim can be found for the first time in paragraph 160 of the complaint at page 45 in the record. And it says that Brown-Rudnick committed legal malpractice by, quote, failing to alert B. Riley to the need to extend the end date, to advise B. Riley of its rights, risks, and obligations under the merger contracts, to even stay cognizant of those rights, risks, and obligations, and to protect B. Riley's interests by alerting B. Riley to the need to extend the end date. Now, that same paragraph appears repeatedly at paragraphs 160, 166, 172, I believe it's 170.
Honestly, this is not, this is Judge Gish, not a great use of your time. We are really crunched for time. So please make your points.
Okay, thank you.
You don't have to give us page sites. They're in your briefs.
Thank you. There are also no evidentiary allegations to support that. In paragraph 79 through 86 of the complaint, it makes quite clear that all Brown-Rudnick did was tell B. Riley that the deal isn't going to close by the end of the year and report on what the parties were telling Brown-Rudnick. They talk about a press release from Vintage and Rack and reporting that. They talk about getting reports from Wilson Sonsini, Vintage's counsel. They talk about agreements with the FTC. Again, B. Riley is really operating in wordplay where they talk about an anticipated closing. It's not Brown-Rudnick that's anticipating that closing. They're reporting that the parties are anticipating the closing. And there's no allegation that that was false. Everybody anticipated that the parties would take care of their business. But it wasn't Brown-Rudnick's duty.
Okay, you have less than a minute, so wrap it up.
Thank you. If I have less than a minute in my final seconds, I'd like to put in a quick plug for causation, which the trial court did not address, but the record is replete with contingencies dependent upon the conduct of third parties. be it RAC, which wanted out of the deal, the FTC, which had yet to even state the terms on which it would approve the deal, other lenders to the deal, and Vintage itself, such that it's unknown and unknowable as to whether this deal ever would have closed. We cite cases in our brief explaining that there are many circumstances where the court has found much less contingent deals to be too speculative. Thank you.
Okay, let's hear rebuttal, please.
Your Honor, there is no blanket rule that a lawyer doesn't have any duty to tell clients anything what's in an agreement. I'm showing you the agreement, which is double spaced over 100 pages. It depends what the law firm is being engaged to do. And after the agreement, it was clearly engaged, like its own billing records show, to monitor to make sure that nothing falls through the cracks. And we didn't say they intentionally misled, but certainly they left an impression that everything was on track. It was just going to be late and not alerting us to what, and I commend the extension provision to you, which is a paragraph long on page 57 of the merger agreement. We had a lot riding at stake here, and we spent hundreds of thousands of dollars on this law firm to tell us all of the deadlines, not just this one, but all of it. That was their job. This is not a motion to dismiss case at bottom. There's discovery on what duties the law firm had. There's discovery from expert witnesses on what the duties were of a deal lawyer in this situation. There's discovery on the damages that B. Riley occurred. Everybody at the time thought this deal on our side was going to close and wanted it to close. There's nothing speculative about that. And we had a downside of $126 million guarantee if there was a termination. And we thought we hired the best firm to assist us so we wouldn't have a situation like this. And these issues, and your Honor's reversed the cases that they cited, the Harding case, on a motion to dismiss, and it ultimately went on summary judgment. But it's too early to get into all of the factual issues on who should have done what and when. All we know is we're out a lot of money, and the law firm wants to get even more money from us.
Okay, thank you. Thank you both. Right. Thank you
Thank
for
you.
your patience and waiting to be heard today.
Thank you.
Thank you.
Okay, Navito versus VNO.
Your Honor, I thought it was Valerio.
Oh, you know what? And you're correct. I'm sorry.
That's
Right,
fine.
we still got a lot to go. So the next case is Valerio versus 265 McClellan.
Yes, good evening, Your Honors, and
Good evening.
Kenneth Mangano for the appellant, Julio Valerio. I'm inclined, due to the length of the day, Your Honor, to rest on my brief. I just want to make 3 points, salient points. The first point being is that Justice Rodriguez, in a decision, completely ignored the German case, German versus Morales. And our position is that under German, a manufacturer cannot avoid liability simply because a plaintiff failed to read the warnings. And I know Your Honors are familiar with the facts of the case. This is a warning label that was manufactured, labeled, and shipped by Hercules. And quite frankly, they admit that this Greek label was placed either in a wrong shipment or in a wrong box. And the issue is, was it foreseeable that such a label on a bottle that's inherently dangerous by its nature would end up on a shelf in a Bronx hardware store? There's certainly a question of fact as to how that happened, why that happened. So with respect to that point, I would urge the court to reverse her on that issue and follow the court's holding in German. With respect to the issue of our amended verified bill of particulars, Justice Rodriguez did not reach a conclusion on that issue because she basically said there was no proximate cause based on the plaintiff's failure to read the label. Respectfully, we did not change our theory in the case. The statutes we cited were consistent with our original theory. And thirdly, with respect to Morales hardware, They don't have standing, Your Honor, to seek a reversal of Justice Rodriguez's decision with respect to their common law negligence claim. She found that was an issue that needed to be litigated, and they did not file a notice of appeal in this case, and they certainly don't have standing to raise that argument as they did in their papers in opposition. Thank you.
Thank you. Okay, let's hear from Hercules first, please.
Sure. Good evening, Your Honors. Meredith Nolan for Defendant Hercules from Lewis Brisbois. I'll also be brief, and I will only address the arguments that were made by counsel. First and foremost, that Herman case is distinguishable from the instant matter. We do refer to that in our brief, and we discussed that. Basically, in that case, the warning was inadequate, and it was also inconspicuous. Those were not arguments that were made by the plaintiff in this case regarding the actual warning. In fact, plaintiff's expert pretty much complimented Hercules on the products, on the SDS sheet, and the lengths it went to make sure this was only sold to professionals. I think the main issue in this case is proximate cause, which is clear that plaintiff did not read the label, didn't even take the bottle out of the plastic. He never asked the person at the store what to use it. And in the absence of him reading the label or even attempting to read the label, there's simply no proximate cause in this case, and that's the main issue. There are numerous cases from this court that hold the same. Counsel didn't even distinguish those in his brief. Briefly, the Guadalupe case, it was also a Drano type cleaner. Young Tung Chow is another one, and more recent cases from 2017, the Medina and the M&H case, which also Judge Gish was on the Medina case. And then even more recently in Reese, the court went so far as to distinguish the Johnson case right in the Second Department and said that even if the warnings are not prominent or conspicuous, that where the user admits to not reading it or even attempting to read it, there can be no proximate cause. So for that issue, we would respectfully request that the order be affirmed with respect to Hercules. Very, very briefly, the cross motion to amend. Two things. Hercules wasn't even named in the amended complaint that was attached, so there's no claims against Hercules there. With respect to the bill of particulars, this is a 2013 index number. The note of issue has already been filed, and the only reason given by plaintiff's counsel for not including the prior, the FHSA and the OSHA is because they didn't know about this until they hired their expert. But knowledge of the law is not an excuse. And if you had looked at, if the council had looked at any of the cases on this issue, the FHSA and the OSHA are mentioned throughout, and there's no reason that he should have known about them. And finally, his expert also even goes on to say that we, exemplified reasonable care. Hercules did. So they lack merit, the amendments anyway, and so they should be denied on that ground. And unless the bench has any questions, I will rely on my brief, which addresses everything.
Any questions, colleagues?
Thank you.
Thank you. All right, let's hear from the Morales Hardware.
Hi, good afternoon, Your Honors. May it please the court, Donna Margie on behalf of Morales Hardware. I will keep this brief as well. With respect to plaintiffs' request to amend the complaint or supplement the bill of particulars, as my colleague said, it's a 2013 index number. No discovery was had on the OSHA or FSHA violations, and knowledge of the law is not an excuse. There was no reasonable excuse offered as to why these allegations were not previously alleged. With respect to the plaintiff's failure to warn claim, the alleged inadequate warning was not the proximate cause of the injuries. Plaintiff did not read or attempt to read the label. The fact that it was in Greek made no difference, even if it was in English. Plaintiff could not admittedly read English, so that wouldn't have changed the outcome. The alleged inherent dangers were open and obvious. Plaintiff admitted that he kept it in the bag to avoid a potential burn or other injury. And with respect to the affirmative relief requested in the respondent's brief, we would just submit that this court does have discretion. All of the arguments laid out in the underlying papers, and it would be judicial economy to review those arguments, given that if this court were to reverse the lower court's decision, the plaintiff's complaint would be dismissed in its entirety as against both Morales and Hercules.
Thank you. Any rebuttal?
Yeah, Your Honor, just briefly, Hercules' position that they placed the clobber product in the stream of commerce with a label that's in Greek, headed for Greece, but ends up in the Bronx, and somehow they want to be shielded behind the concept that since this plaintiff, who admittedly is illiterate and cannot read either English or Greek or whatever, because he doesn't take it out of the bag and say, geez, you know what, I have no idea what this is about. If they had properly labeled it, placed it in the stream of commerce, maybe, just maybe, Morales Hardware's employee would have been able to read the label, and it would have been foreseeable for them to say, well, you know what, this says for professional use only, I should not be selling it. Nonetheless, they too ignored any indication one way or the other if it was for professional or for residential use. And Hercules should not be provided the privilege of being rewarded, behind the shield when they're clearly negligent, admitted that they were negligent, and nonetheless, because he doesn't look, they get the benefit of summary judgment. Respectfully, the lower court should be reversed. Thank you all very much for your time, and thank you for the opportunity. Judge Shulman, it was nice to see you. It's been a long time. Thank you very much.
Thank you, counsels, and thank you for your consideration of our calendar and sticking to the time periods that I gave you, and for waiting such a long time to be heard. Have a good evening.
Take care.
Thank you. Have a good evening.
Okay, the next case is Navido versus BNO.
Yes, hi. Good afternoon.
Go ahead.
Sophia Uveda here on behalf of appellant respondent SJ Electric in its capacity as a third-party defendant only. SJ has been dismissed by the plaintiff from the first-party action a few years ago because, as our papers show, there's really no evidence tying SJ's acts or negligence to the happening of Mr. Navido's accident. With the court's permission, I'll quickly go through the common law indemnity and then the contractual indemnity claims. On the common law claims, third-party plaintiffs, Lend-Lease and V&O, admit in their papers to this day that they don't know what caused Mr. Navido's accident. They're simply suing SJ because SJ provided electricity to the site. As Justice Gish pointed out earlier in the afternoon in Lopez versus City of New York, the summary judgment standard is very well known and basic. All SJ has to prove is that it was not responsible for the accident, which it did. It proffered the testimony of its foreman through the deposition, saying that he was immediately called after the accident to come down to the 40th floor where Mr. Navido was injured. He called his electrician, James Stonkus, and under his direct supervision and eyesight, Stonkus tested all of SJ's equipment near the site to make sure that it wasn't, it didn't have problems, it didn't have a short, and the testing revealed nothing. SJ further had to provide electricity to the site, but the 480 volt power grid that we pointed in our brief is on page 3096 for visual reference. That was 8 to 10 floors above the accident site. So that was nowhere near where plaintiff got hurt. That is affirmative proof that there is nothing that SJ did that negligently caused this accident. In opposition, Lend-Lease says, well, we don't know what happened. They submitted multiple rounds of papers, they submitted an expert affidavit, and in their reply brief, they admit they don't know what caused the perimeter cable to become electrified. They somehow try to switch the burden of proof on summary judgment to say that it was SJ's responsibility to tell you exactly how the cable became electrified. prima facie burden does not require SJ to put on an investigative hat and to find out who did it, just to show that it wasn't them. That burden was met, and in opposition, Lend-Lease cannot raise a question of fact. Although we don't have to, I think our underlying papers do show that the overwhelming amount of evidence points to the outside hoist that was running out near the perimeter cable as being the culprit of the electrocution, and that was run by non-parties Enclose and the fourth party defendant, Greg Beach. Lend-Lease also tries to throw in some red herrings to talk about the admissibility of certain documents, and they're just that, red herrings. The testimony of Gillespie, deposition testimony, is in fully admissible form. He was there during the testing. He's our prima facie evidence. And the fact that James Stonkus's statement that Lend-Lease itself obtained was not sworn is immaterial to show if we met the prima facie burden. If there's no question on the common law, I'll move on to the contractual indemnity. The contractual clause between the Lend-Lease and SJ contract requires indemnity for all claims caused by or arising out of SJ's work. That still requires a causal relationship between our work and what happened to the accident. It does not, as Lend-Lease propose, mean that if we're providing electricity, every electric accident or any electric accident that happens on that site, we have to indemnify the owners and Lend-Lease for. That defies the strict construction reading of indemnity clauses, and it just leads to absurd results. That's not how the court is supposed to interpret contracts. The Court of Appeals in Worth clearly said that arising out of requires a causal relationship. Lend-Lease in opposition said, well, that doesn't count because it was a coverage decision. This court repeatedly applies the Worth standard of a causal relationship to contractual indemnity clauses all the time. We cite quite a few contract cases, but I think the more relevant ones are the ones that this court and this bench decided in just the last few months. That's Vasquez versus City of New York, where Judge Gish and Justice Kennedy were on the panel. You were interpreting the all safe arising out of in connection with the work.
So, Counselor, I'm sorry, your time has run out. I'm going to let you wrap it up. So wrap up your point and we'll hear from the other side. Thanks.
Yes, so I pointed out Vasquez. I also wanted to point out Arias versus Sanitation Salvage, which is also, Your Honor, Judge Gish and Justice Mendez. If the court has no further questions, I will rest on my brief and reserve, and address anything else in rebuttal.
Thank you. Any questions, colleagues? Okay, so let's hear from V&O.
Good afternoon.
Cross appellant, go ahead.
Good afternoon. May it please the court, Patrick Lawless for cross appellant V&O and Lend-Lease. SJ glosses over the fact that their motion was denied because they failed to come forward with any admissible evidence. Their motion below relied exclusively on hearsay statements, an unsworn statement, unauthenticated photographs. Now they rely on Gillespie's testimony. But Mr. Gillespie, with respect to Stankin's inspection, provides no details. It doesn't say what type of meter Mr. Stankus used, whether it's an OSHA approved or what type of meter he used and what the effect was of that inspection. He actually testified too, when he was asked what was the cause of it, he said, I can't say. Also, SJ completely overlooks the testimony of Alemco's witness. Now, Alemco is a subsidiary of SJ, and they were hired to perform a post-accident inspection. Now, their witness testified that their inspectors didn't test all SJ's equipment on the floor, and that he couldn't say. He couldn't come to a conclusion that SJ wasn't responsible for the accident. SJ refers to these issues as superfluous admissibility issues, but it goes to the core of their burden as a movement on summary judgment to come forward with admissible evidence to eliminate all issues of fact, and they failed to do so. It's ironic because it's actually SJ that tries to shift the burden to V&O and Lend-Lease on their summary judgment motion. Now, moving to the contractual indemnification issue, there doesn't need to be a finding of active negligence on SJ's part, just that it arose out of or occurred in connection with their work. Now, they didn't just, their responsibilities weren't just provide, I mean, it's undisputed that they were the sole supplier of electricity to the upper floors, including the floor that the plaintiff was working. But they also had contractual obligations that went beyond that. And they were an active presence at the site. And among their responsibilities included coordinating all electrical power requirements, providing all protected devices, including circuit breakers, fuses, switches, ground fault protection, transient voltage surge suppressors, grounding and bonding. They're responsible for erecting and maintaining barriers. They were also responsible for performing weekly inspections of all the temporary electrical equipment that they had set up. So that just goes beyond to just turning on a switch and providing the power to other people. Also, SJ tries to point the finger at other entities, but again, if you look at the testimony of Alemco's witness, SJ tries to make it seem that it was caused by Enclose or Biche, and that there was some hanging cable, but Alemco's own witness testified there was one hanging cable, but this was properly enclosed and couldn't have been a source for electricity. So based upon that, not only did SJ fail to meet their burden on summary judgment, but based upon that, at the very least, V&O and Lend-Lease demonstrated their entitlement to conditional contractual indemnification. And that's all, unless you have any further questions.
Thank you. All right, co-respondent.
Yes, Scott Singer for the plaintiff respondent. I'm not going to, because the main defendants did not address my claim in their argument. I'm not going to burden the court with much of a discussion. I just would point out, first of all, it's absolutely undisputed, as the Supreme Court proceedings made clear. There was no question whatsoever that this perimeter cable was electrified. That's not in dispute, regardless of whether anybody says it could have been carried voltage or not. It did carry voltage, and nobody disputed that in the Supreme Court proceedings, or as a practical matter, there's no, it's unrefuted. Secondly, I did cite in my brief 6 cases in which a worker was injured as a result of an unprotected electric network. There is no requirement, clearly no requirement, that the purview of Industrial Code Section 23-1.13 is limited to cases where there's contact with a dedicated or purpose-built network. The main defendants haven't bothered to refute any of those cases, so they're pretty clear and undeniable. Kutea, Harris, Rubino, Snowden, Bardoi, and Haynes all stand for the proposition that it doesn't matter if you touch a pipe or your Hilti gun touches an electric network, or if it's your safety harness, or there is an explosion. All those scenarios, liability predicated on a violation of Industrial Code Section 23-1.13 was found. So this
is Judge Gish. Just a quick question. So the safety cable, it became electrified. It wasn't supposed to. Is it in the record that it was electrified because there was a loose wire that it came into contact with that was in the electrical network, as it were, supplying from the perimeter scaffold? Is that what's going on here?
I mean, there was testimony that there was hanging cables that came from a hoisting or a monorail system, they called it. There were loose cables, and there was also evidence that one of those cables, there was a short detected in it. I can't say beyond that what the source of the electrification of the preliminary cable was, but it's undisputed that it was electrified. And it's also undisputed, as the court found, the Supreme Court found, there was no investigation, there was no warning, there was no de-energizing of the network, and there was no protective equipment, specialized protective equipment provided. So for all those reasons, the court found that a violation of Industrial Code Section 23-1.3 and hence Section 241(6) was established. I hope that answers your question, Judge Gish. I don't know.
It does. It does, to the extent that it does.
I think the assumption is that that's the evidence points to these hanging cables. Who's responsible for that? I can't say. It doesn't really matter because there was a clear violation of the industrial code. So I hope I saved you a little bit of time. Unless there are further questions, I'll rest on my brief.
No, thank you. It's fine. Okay, SJ, your rebuttal?
Yes, just a brief rebuttal on just following up from Mr. Singer's statement about the hanging cables. I believe both the plaintiff and his partner testified that that was their understanding, that the monorail cables came into contact. To be clear, the monorail cables were not the responsibility of SJ. Those were attributed to Enclose or their subcontractor, Greg Beach, who is a fourth party defendant, also represented by the same firm as the owners, but they're not part of this appeal. And then just to address briefly the points raised by Lend-Lease and VNO on the admissibility issues, at no point in time in the underlying, I think there's 4 rounds of briefing, 1 expert testimony, and 7 rounds of oral argument, did Lend-Lease ever say, well, Gillespie didn't testify with sufficient detail. That would be subject to something that their expert could have opined on, but they did not. They never said through their expert that SJ did something wrong. So to say that a foreman, because he can't identify the cause of the accident, cannot eliminate his own work, cannot eliminate SJ or recall what his testing revealed, that's just inaccurate. They point to Alemco, which was a related subsidiary of, or related company of SJ. They said, well, Alemco did not rule out SJ. That is absolutely true. That's because Alemco wasn't hired to test any SJ equipment. Alemco was hired to test Enclose's equipment. And that is the only thing they did. Repeatedly in the deposition of the engineer who tested it, or the electrician, they said, that's what I was hired to do. That's the only opinions I formed. I did not test SJ equipment. I did not form an opinion. That's because Gillespie and Stonkist already tested the SJ equipment earlier in the day, and they ruled out shorts in the SJ equipment. The last point on the contractual, my opponent, Mr. Lawless, read through a number of things that we were supposed to do in the contract, coordinating power requirements, getting permits, putting up signs. Nowhere in his argument or the underlying papers did they make a connection between those responsibilities and how that related to this accident. It's not clear how getting permits was supposed to have caused a perimeter cable that shouldn't have been electrified to become electrified. Okay. Like, there is no causal connection between all of those responsibilities. And for those reasons, respectfully, the court should reverse and grant summary judgment to SJ dismissing the third party action.
Thank you. Mr. Lawless, you have 1 minute.
Sure. I just read all the responsibilities, and it goes more than just simply obtaining permits. It has to do with providing safety equipment and performing inspections. And with respect to any claim that there's evidence in a record that the cable was electrified by a hanging cable, that is based on hearsay. There's absolutely no admissible evidence what caused this. And in fact,
since I put that issue at play, does it really matter? you have the safety cable, it was electrified, and it shouldn't have been. It wasn't designed to carry electricity. Isn't that enough?
Well, for our issue is, well, there's two issues, but our issue is that number one, that whether this arose out of SJ's work, and SJ was the sole supplier of electricity, and they had ongoing responsibilities. They were an ongoing presence at the site. All the cases that they cited in their papers had to do with a contractor or a subcontractor that had a very limited role, and in most cases weren't even present at the time of the accident, where SJ was. And SJ just didn't turn on the switch and walk away. They had all these ongoing obligations. And with respect to how it became electrified, well, with respect to the industrial code violations, it's just our contention that it specifically refers to power sources, and this wasn't a power source. So, but any attempt to argue by SJ that this was the cause of the accident is not supported by any admissible evidence in the record, and in fact it was specifically discounted by Alemco's witness.
Okay, thank you. Thank you all. Thank you
Thank
for
you,
being so patient today.
Thank you for your patience.
Okay, finally, we have on today's calendar Consolidated Restaurant versus Westport.
Good evening, Your Honors. Ori Levy for the appellant CRO. May it please the court. At a fundamental level, this is a case about pleading standards. CRO has alleged in excruciating detail that the coronavirus, a dangerous physical substance, invaded its rrestaurants, attached to property within its restaurants, tangibly altered the air within the restaurants.
Counsel, this is Judge
Yes.
Owing. We
Yes, Judge.
have the facts here. You know, your pleadings, as good as they are only going to be good if you got coverage under your policy, right? I mean, that's the bottom line. You could have a well-pleaded complaint, but if there's no insurance coverage, it doesn't matter. So let's get to the heart of it. Where is it in the coverage portion of the insurance policy are you entitled to coverage? Because it's not a physical loss, or that's the whole issue. Is there a physical loss or physical damage to your property?
Absolutely, Judge, and I appreciate the question, and I'll jump directly to the heart.
Yeah,
of it.
because it's been a long day and we just want to go right to the point.
Absolutely, not interested in wasting anybody's time. So
tell us.
Let me cut to the heart of it, right? The fundamental question here is a physical, invisible, noxious substance, physical loss or damage, assuming you take our allegations as true. And I have three reasons why the answer is yes. The first is that under the plain and ordinary meaning of those terms, those undefined terms, physical loss or damage, in the context of this policy as a whole, invisible substances do meet that language. And here's why. This policy expressly considers invisible substances, contaminants, as physical loss or damage by its plain terms. For example, the policy describes radioactive contamination as physical loss or damage. It describes a host of invisible substances such as fumes, gases, toxins, dioxins, smoke, all of those types.
I have to say, I didn't think that the issue here was whether it was invisible or not. I think that the issue goes into the physical loss, the physical alteration, and part of the problem really comes from the issue of to what extent that you are claiming, and can you claim that physical loss is really loss of use?
Well, Judge, I want to put a fine point on that because we are not arguing that this is a pure loss of use case. That's when roundabout applies. We are arguing that this is a case involving a loss of use stemming from a tangible physical impact to property. And that impact is the presence of a virus. And prior to the COVID-19
hold on a second. Hold up. You just said something very, very, very critical. A virus.
Yes.
And if I read the briefs and the record here, this virus is coming on by human carriers, human people, humans coming into the restaurant. And if you bar the access to humans with this virus, then where's your physical loss and where's your physical damage?
2 points, Your Honor. First and foremost, if the only way to stop a physical impact to your property is to close the doors of your property, that's exactly what these policies are designed to cover. And I'll answer with an analogy.
I'm not sure that's right. I think that there has to be a physical loss, but as a result of, not that you have to take prophylactic measures to prevent physical loss. That I don't think is covered in the policy. I don't think that's at all.
Well, there's two separate steps, Your Honor. First, there is a preservation of property elements coverage to this policy, which says that you get coverage for the time in which you are essentially shut down to avoid an imminent risk of physical loss or damage. That is the protection of property coverage.
But Mr. Levy, I'm sorry, Justice Shulman, but you weren't shut down. You actually operated your kitchen and catered, no pun intended, to drive-bys and that sort of thing. The only thing you were deprived of was having in-house meals.
And the policy accounts for that.
And most of the cases that address noxious substances of that nature is as to render the space uninhabitable. And that was not the case here at any time, notwithstanding the mandate to shut down, because the mandate shut down your ability to have customers come in. It didn't shut down your ability to service your customers by preparing meals on the very COVID-infected surfaces by your staff, preparing these meals that were picked up at curbside or whatever protocol your constituents exercise. Would you agree with that?
Well, I would agree with your factual description. I would disagree with its import in connection with this policy. And I think there were 2 points in there, if I could distill what Your Honor said, and I'd like to address both of them. First and foremost, this policy covers a circumstance where there is even a partial prevention of your ability to use your property. It expressly contemplates that scenario. And the reason why is, let's say you have a physical loss or damage that impacts one part of your property, but not another. The policy says we're still going to cover that, meaning if there was a flood of the dining area.
That's a physical impact. That's a physical loss and damage, just like a fire in the kitchen or in the basement that prevents you from using part of it. You're perfectly correct in that regard.
And the analogy I would draw,
you need both. You need both, sir. No?
Yes, and the analogy I would draw for Your Honor is that we are no different than the dozens of cases involving ammonia, salmonella, E. coli,
Okay,
odors.
counsel, and then you hit a really good point. Okay, so that you're saying that the virus here caused you, or you're arguing that there is a physical loss or physical damage to your property, to the premises, right? So that, okay,
Yes, Judge.
Now that we eliminate the virus, let's just say the virus is gone, what has changed on your property? Have you now have new tables, new chairs, new physical attributes, or are you using the same items? Because when you have a physical loss or a physical damage as a result of a contaminant, like whatever contaminant, or if there is some sort of radioactivity, you got to get rid of everything and replace everything, or there's a flood or a fire. But with your analogy, what new items have you brought into the restaurant as a result of the virus ending?
Well, Your Honor, first of all, we have alleged that we have engaged in repair or replacement in various ways, but I want to set that aside because I think there's a more fundamental point I need to address here, which is that take a scenario where you have a flood of a cement factory, for example. Water comes in, you can't make your cement. 2 weeks later, the water evaporates. No insurance company would say that didn't constitute physical loss or damage, but I didn't have to.
Because it probably damaged your equipment. Your equipment's probably damaged.
Right.
But the point I'm making here, Your Honor, is that we're at the motion to dismiss stage where we have made allegations that we've engaged in repair or replacement. We've made allegations that the virus is resilient and difficult.
But here, Judge, I know you've made those allegations, but to what extent are they merely conclusions? I mean, if all you have had to do to your property, and this was sort of in the lower court decision, is just clean it, does that constitute a repair or replacement or rehabilitation that is otherwise contemplated by physical loss under this policy?
And the answer, Your Honor, is yes. And it's a yes based on decades of case law reaching that conclusion in the case of a host of noxious substances, such as ammonia, which naturally dissipates, carbon monoxide, which naturally dissipates. This is a debate about damages.
Well, the ammonia case that you rely on, that was under New Jersey law, quite frankly. Although it was, certainly the reasoning might apply or it might not apply. It's certainly not binding on us.
Certainly not, Judge. I'm not citing those cases to suggest they're binding. I'm citing those cases to suggest that they implicate New York law in terms of the policyholder's reasonable expectations. You have a term in an insurance policy, physical loss or damage, that basically up until COVID-19 has been interpreted by courts in a certain way to cover things like ammonia, salmonella, and E. coli. And that's why insurance companies include broad exclusions for viruses in their policies, an exclusion that Westport didn't include. They're asking you to say our policy basically doesn't cover damage from contaminants. So the fact that we didn't include a virus exclusion, you can just forget about that. The fact that we included an exclusion for a whole host of things.
Does it matter? At one point in the policy, or maybe I'm wrong, they do define contaminants as including a virus, no?
They do, Judge, but that type of exclusion has been conclusively determined under belt painting by the Court of Appeals to only apply to traditional environmental and industrial contaminants. It would not apply in this circumstance. I actually think that argument strongly supports us. The policy has an exclusion which excludes viruses under very specific circumstances, but not others. The virus, the contamination exclusion would be entirely superfluous if their reading of physical loss or damage was right. And I'd like to go back to this concept of the reasonable expectations of the insured, because under New York law, that is the guiding principle for how you interpret the terms physical loss or damage. And if you're a reasonable business person and you look at this policy and the policies in the marketplace, and you look at decades of case law in cases like ammonia, E. coli, salmonella, you look at this policy and you say, okay, so they're identifying expressly types of loss or damage. And under that category are fumes, smoke, gases, things that naturally dissipate. And then you say, all right, well, I'm going to buy a policy that doesn't have a virus. And then your property is shut down. You can't use it because they have a physical substance pervading the air. If people come in, they could die from it. And you're shut down.
Hey, but that's a very different situation when you're dealing with a virus that humans are carrying. It's not. It's when you look at a contaminants like a gaseous contaminants like carbon monoxide and whatever examples you've used, that's not being carried in by a human. You can't stop that. That's just coming in. You're not right. It's somehow it's a gaseous substance that's going to permeate and invade the premises. Whereas when you're dealing with when you're dealing with an illness or a virus that are carried by humans, you can stop it. You can stop the entry of the humans. So that's a big problem. And that what you're arguing is, for me, is trying to really expand the notion of physical loss and physical damage. You want us to expand that definition to include something that, in some ways or another, the policyholder can control. You can control what comes into your restaurant, but you may not be able to control contaminants that come in. Somehow there was like automatic and immediate release of carbon monoxide that's coming from a gas furnace. You can't control that because there's something that happens. So you're asking us to do a heavy lift in terms of expanding what is physical loss and physical damage, when it's something that, as a policyholder, you do have somewhat of control in terms of how how it impacts your physical premises.
I'm gonna
You know-
let you, I'm gonna let you respond to Judge Ewing, but we're way over the 10 minutes. So after that, we'll hear from you, our adversary.
Sure, I want to really focus in on the core of that question, because I want to challenge the notion that you can draw that type of distinction between the coronavirus and this whole host of other substances based on the premise that it can be brought in by humans. And there's two reasons, it's about 5 reasons for that, but I'm going to settle on 2 because of my time constraints. Reason number 1, this policy is completely agnostic as to how a contaminant gets onto your property. The question is, did it get there? And once it got there, what was its impact? And the second point is, Your Honor's question is an excellent question if the issue here was about damages and not about trigger of coverage. Because in the early days of the pandemic, for example, in April and March, people were coming into that restaurant asymptomatic, carrying the virus. The restaurant had no idea. They wouldn't have known to close their doors. And they were leaving the virus all over the place. And we've alleged and cited the scientific studies showing that the virus is resilient and lasts for days and weeks. So I take Your Honor's point, although I disagree with it for other reasons, but I take Your Honor's point in as much as it takes us toward the later period when CRO might have known what the threat was. But in those early days when it had to close for a month, for 2 months, I don't think that distinction holds. I have a few other points I'd like to make on that, but I'll save it for rebuttal, Your Honors. Thank you.
Thank you. All right. Can we hear from Westport?
Yes, you may. Good evening, Your Honors. Thank you for staying so late with us. Aidan M. McCormack with DLA Piper. I'm counsel for defendant Appellate Westport Insurance Corporation in this matter. Westport, of course, respectfully requests that Your Honors affirm. We've submitted some unreported cases to Your Honors, and I just wanted to bring you up to date on that. As of today, there are 66 trial court decisions in the state of New York on this very issue. Every single one of them has dismissed the claims for COVID coverage under the same property wording here. There are 25 appellate decisions across the United States right now on the very issue before you. Every one of those 25 decisions, unanimously, 25-0, has dismissed the very COVID claims at issue here under the very property wording issue here. The policy at issue, purchased by a sophisticated insured, advised by a sophisticated insurance broker locked in, requires direct physical loss or damage to insured property. Insured property is defined to include real and personal property, not humans and air. We all know that COVID was a huge challenge. I'm sure many of us lost loved ones. This is not a life insurance policy. It doesn't insure lives and health. It insures real property, physical loss or damage to real property. And there's 2 particular provisions that counsel alluded to in the policy that I certainly want to make note of. One is the period of liability provision. You will find that on page 115 of the record. The other is the valuation provision. You will find that on page 131 of the record. Why are they important? Because the way you measure loss under a property policy is by the time and value of either repairing what's been damaged, for example, given like in a fire, or the destruction, the total loss of something. Here, contrary to counsel's statements, if you study the complaint, there are in fact no allegations whatsoever that there was the repair or replacement of real property that caused the loss. We all know what caused the loss. Let's deal with reality. The fact is there was decreased patronage in the restaurants because people were socially distancing and government was restricting people's movement. For what purpose? To protect their health, not to protect the property, even though I agree with Your Honor's comment that this isn't a protection of property policy. In fact, if you think it through to the bitter end, these properties suffered less wear and tear during this period rather than more because of the decreased patronage. And ultimately, their financial losses, as difficult as they are for many institutions, do not arise from direct physical loss or damage to insured property. I think Judge Caproni said it very well in the Social Life case when she commented, in quotes, COVID-19 damages lungs. It doesn't damage printing presses. Ultimately, People aren't wiping down surfaces with disinfectant to protect those surfaces. They're doing it to protect human contact with those surfaces and reaching another human contact. They're doing it to remove the virus. And the property, as the recent Kimchi Second Circuit case said, is not seriously impaired or destroyed. It is simply a passing sweep of a disinfectant, not for the purpose of protecting the poor table, but for protecting human beings. It's entirely different. Courts have repeatedly recognized that short-lived things such as COVID-19 are not the subject of property insurance. You have the Mama Joe's case involving dust, the Universal Image case, the Mastodon case involving mold. Very good analogy there, because in those cases, the mold could be wiped off the surface with some disinfectant. And the courts found that that did not trigger coverage under the policy. And of course, the oft-cited Port Authority case, which recognized that asbestos in buildings is not direct physical loss to tangible property. Now, there was a comment made, so I want to address Gregory Packaging. Gregory Packaging is the unreported district court decision under New Jersey law. That is a ammonia release case in which the fire department directed everyone out of the building, and specialists in hazmat suits need to be returned to the building to decontaminate it. It is completely different than the COVID-19 facts here. And I will add this to that. The New Jersey justices, who are all deciding the same issue before them, have repeatedly, time and time again, distinguished Gregory Packaging as not applying to COVID-19. Judge Lynott in Essex County issued a decision yesterday, exactly that. So even New Jersey, which is not the law here, we have a choice of law for New York here, even New Jersey is not following Gregory Packaging and distinguishing it in the context of COVID-19 cases. So it is truly a very different circumstance. I also want to address the reliance on the Slam and Stone case. Consolidated points to Stone, this is, I think you know this, but is a New York County decision, trial court decision. But it's a very different case, and let me give you some reasons that I think it actually fits nicely in with where we are today. In that case, the tragedy of 9/11 left dust and debris in the facility. Very sad, and I know many of us lived through it. The carpeting in the building, they tried to repair it. They could not clean it. They could not get the dust and debris out. So they had to take the carpet out and throw it away and completely repaste it. That is called repair or replacement. That's what the policy ensures. That is not this case, right? This is not a case where they threw out the tables and chairs and the knives and the forks. It is very different. And it's important to remember two other things about Slamstone. One, there was another element to the claim. The other element to the claim in that case was that because the 9/11 government shut down the area to secure it from military attacks, the court found that was not covered. That was not damage. Very similar to what occurs here, right? And ultimately, it's about Slamstone didn't have a provision that allowed coverage in absence of direct law. So also comment on preservation of property.
Mr. McCormick, I don't know about my colleagues, but I'm having trouble hearing you. So let's see if we can't make an adjustment, because we're all recognizing from each of you that this is an important case for us.
Thank you, Your Honors. Is it better now?
Yes, it is.
Okay, thank you. So the protection of property provision preservation of property provision is on page 1, 2, 3 of the record. This is sort of a new argument that's just I want to, you have to actually read it all the way to the end, because the end it says that is only any action to protect property.
We're having problems hearing you again. Even Mr. Levy is, I can see.
The opposing counsel, would you mind turning off your mic? Maybe that's it. I don't know. And I'm sorry to ask you to do that.
He did. He is muted.
I apologize.
No, you don't have to apologize. We've had technical problems all day today. Actually,
Thank you.
Yeah, go ahead.
All right. So the protection and preservation of property provision on page 1, 2, 3 of the record, it specifically requires the immediate pending direct physical loss or damage to insured property under the policy. So it doesn't change the question before the court. The question before the court is, was there direct physical loss or damage to insured property, which is defined as real property, necessitating its repair or replacement, which caused the financial losses suffered by consolidating? And we say no, there wasn't. I think to add to it, there is also mentioned previously 2 exclusions that are important to remember. The first is the contamination virus exclusion. It's very important to understand that this exclusion is not, as my learned adversary would like you to think, some old-fashioned pollution exclusion. It expressly excludes toxins, pathogen or pathogenic organisms, disease or illness causing agents. What is COVID-19 other than a disease causing or illness causing agent? And as Your Honor previously noted, it expressly excludes a virus. You'll find that exclusion on page 143 of the record. And also, you might want to look at the Northwell decision.
With respect to that, your adversary cited the Belt case, the Beltway case, the Court of Appeals case, which looked at the precatory language to that exclusion and said that was what made it an environmental pollution. And this policy seems to have very similar precatory language. So where's the distinction there?
Yes, the belt painting didn't define virus. And more importantly, on the prefatory language, Your Honor, belt painting was into the land, atmosphere, or water of a pollutant, okay? This one is a broader dispersal or discharge. And I commend to you reading Judge Rakoff's decision where he addressed this exact issue. Remember, belt painting was a liability policy with a traditional pollution exclusion where the claim was one for lead poisoning from painting, I think, the Williamsburg Bridge. It's not our case. And so in this context, what Judge Rakoff recognized in Northwell, and he studied the exact issue Your Honor's raised in the context of COVID-19. And he said, and the site for that is 221 Westlaw 313-9991. What he said was that this language, which is exactly the language I have, is materially different than the language in belt painting, such the correct understanding. You put the word virus in there, the pathogens, the disease-causing agents phrases, that this exclusion applies. It is not a traditional pollution exclusion. It is a very different modern contamination exclusion. I would also mention that there's also the microorganism exclusion. And I know that you may have looked at that. That's in the record at page 128. The microorganism exclusion excludes coverage for loss due to a microorganism, and you have to listen to this, of any type, nature, or description.
So the argument there is that it has to be alive. No?
Well, that, Your Honor, is their argument, their scientific argument. But Consolidated itself alleges that it's highly contagious. You can see that in the record at page 55. And the coronavirus is certainly a microorganism of any type, nature, or description. And I would suggest that you read a brand new decision by the Seventh Circuit, admittedly, under Illinois law, but on COVID, that deals with this exact issue. And that's Crescent Plaza Hotel versus Zurich. It's 20 F4th at 303, 20 F4th at 303. I couldn't do it better than they do it, because what they explain, and what I respectfully submit is your role, is not to get into some scientific distinctions, but think what the ordinary person, especially a sophisticated insured, would understand when they read a policy that excludes a microorganism of any type, nature, or description. They would understand that a virus, which the CDC has said coronavirus is and falls within the definition of microorganism in the dictionary, is just such a thing. So if the Your Honors have no questions, I can rest.
Right. Any questions? Give us a lot to think of, both of you. Mr. Levy, your rebuttal.
Your Honor, I'd like to.
Can you do it in 2 minutes?
Well, that depends on how many questions Your Honor's answer, because I got to answer them fully, but I'm going to do my absolute best. I'll keep it short.
No, go ahead.
I've got maybe 3 points, and I'll try to keep it targeted. Number one, I heard that there are apparently 66 of the same decisions and 25 appellate decisions that all kicked COVID-19 cases. That is simply false, Your Honor. The vast majority of those cases were cases where the virus was not alleged to be present on the property, or there was an ISO virus exclusion that Westport didn't include in its policy here. And so the overwhelming majority of those cases are just don't even come anywhere near the situation we have. And in the much smaller number of cases where you didn't have an exclusion and the policyholder had alleged physical loss or damage as a result of the presence of the virus, those decisions in New York were almost entirely predicated on roundabout. And for the reasons that we briefed extensively, that is a misapplication of roundabout that significantly narrows the traditionally available coverage for physical loss or damage caused by the presence of these types of substances. Second, by and large, what I just heard is an incredibly compelling summary judgment argument based on a record of counsel's invention, because it flies directly in the face of almost everything we have alleged. So yes, if you reject off the bat the truth of all of our factual allegations and accept as fact all of the insurer's argument as being what we alleged, then of course we lose. But that's not the standard. The standard is that our allegations must be accepted as true with all reasonable inferences drawn in our favor. And the example I'll give is that my opposing counsel's argument presupposes that COVID-19 is just like dust. You could wipe it away with a sweep of a rag. Not only is that directly contrary to our allegations, which, by the way, are supported by citations to scientific evidence, I think it's contrary to the lived experience of literally billions of people. So I think I'll stop on that point. The last point I'd like to make is about the exclusions, Your Honors. First of all, Judge Rakoff found that by the way, my firm was counsel in that case, so I know the case very, very well. And Judge Rakoff found that the contamination exclusion didn't apply because he found that COVID-19 qualified as being released because you could sneeze it out. I don't know what more to say about that, but it is so directly contrary to the conclusion and understanding of belt painting that I think that juxtaposition should speak for itself. But more to the point, why in the world did Westport include a contamination in its policy for communicable diseases that result in physical loss or damage under very specific circumstances not applicable here, if a communicable disease could never constitute physical loss or damage? I did not hear a retort to that sort of logically mind-boggling situation we've got there. How could the contamination exclusion do any work under Westport's interpretation of the case? It can't. Lastly, Your Honor, I'd like to talk about the microorganism exclusion for a second. And this goes back to are we having a summary judgment argument or a motion to dismiss argument? Because we have alleged that the virus is not a microorganism. There's reasonable scientific debate on that. And based on, 100 years of insurance policy interpretation, where two experts disagree about whether something falls into a policy term, that is ambiguity on its face, where the term gets construed in favor of the policyholder. And I'd like to conclude with a thought, Your Honors. I understand that each of us has lived with COVID-19 for too long now. And each of us, in order to assess risk in our own lives, has come up with conceptions and ideas about the nature and impact of COVID-19. And I think that a lot of these decisions that opposing counsel are pointing to are decisions where judges have allowed that predilection to infect their legal reasoning and conclusions. Because in those small number of cases where the motions to dismiss were granted, they invariably have a judge saying something like, well, of course you could clean COVID-19, because maybe that was their own experience. but it's contrary to our allegations. And I submit to your honors that it's contrary to the science. And so the question at the end of the day is, will the court credit our allegations as true and give us an opportunity to prove them through discovery? Or will the court do what opposing counsel is asking and turn the standard on its head and credit facts that are outside of the record? Frankly, there is no record, in order to reject the truth of our allegations. Your honors have no further questions?
Would it be permissible me to address 2 points in 15 seconds?
No, as important as this case is, your briefs, quite frankly, are magnificent, and we have the added benefit of the amici. So I think we have a lot to chew on, and I think we can address the points without the 15 seconds that I have now used up. All right.
Good night, your honors, and thank you.
I thank you all really for your patience and for the high quality of argument.
Staying with us, Your Honor.
The session of the appellate division is now closed.